I call this meeting the Judiciary Committee to order. Members, take your seats. A quorum is present. Members, today we've got 4 bills. We've got HF 998, Representative Ecklund. We've got House File 1971. That's my bill, the forfeiture bill. A lot of people here on that, I think. House File 2083. That's Chair Considine's. Hey, can I have you quiet down in the back room? Thank you. Chair Considine has corrections omnibus data practices bill that Chair Considine is not here. He has a committee right now. And then Representative Daudt has House File 1731. Representative Ecklund, are you ready to go on House File 998? And members, last time we had an issue with the amendment. And the amendment, I think everyone has on time now, and it was posted. So who's going to be offering that amendment? Oh, Representative Cantrell offers the amendment on House File 998. It is the A19 amendment. So, Representative Ecklund, did you want to speak to that? The A19 amendment?
Actually, Mr. Chair, I'll have Mr. Hunter speak to it because he speaks lawyer better than me.
Thank you, Mr. Chair. Members of the committee, the amendment just addresses a couple of issues that came up in our ongoing discussions with the County Attorneys Association. The first of the amendments specifically states that this statute would apply to misdemeanor and gross misdemeanor offenses so that there is no confusion about that. The second amendment addresses subsequent uses of this statute if a veteran has already previously been sentenced under this statute, and gives judges broader discretion to deny the benefit of the statute if a veteran has already been before the court and received the benefits of the statute in the past.
Okay, so you said there's 2 amendments. All we have is the A19.
Well, I apologize, Mr. Chair. It's 2 separate tweaks to the language of the bill, both in the same amendment.
Okay, fair enough. Any discussion on the amendment? Seeing none, then all in favor of the A19 amendment signify by saying aye. Aye. All opposed say no. Motion passes. To your bill as amended. Representative Considine. I'm sorry, Representative Ecklund.
Thank you, Mr. Chair.
I was thinking about Representative Considine coming in for his bill, which is why I said that. Go ahead.
Representative Considine and I spent a lot of time together. So
yeah, you guys hang out.
So so I think that's where we were at last week on this, Mr. Chair. We'd heard most of the rest of the bill and had some discussion on it. On page 4, line 4.23 and 4.24, there was some possible language things that I didn't know if we can do an author's amendment to fix those. It looks like on 4.23 that should be A rather than B on the very first letter. We think Representative Mueller and I talked with staff about that to see if that's right. It's still not quite clear, but that's the way we look like it should state. And then on 4.24, whether we should just take the word durational right out of there. Other than that, Mr. Chair, I think we addressed most of the bill last week.
Okay. So, the chair would consider those technical, and I wouldn't object to those amendments at this time, but we've got 4.23, the first, change the B in parentheses to an A, and on line 4.24, remove the words or durational. Is that right?
That's correct, Mr. Chair.
Okay. Any discussion on that oral amendment? All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Okay. Go ahead, Representative Ecklund.
Thank you, Mr. Chair. And I think with that we went through with the majority of the bill. So I guess I would think that if the members have any more questions on it.
Okay. The members have questions to this. There was brought up, Representative Ecklund, our request for information regarding expenditures. Do we have those? I haven't seen them like before.
That's correct, Mr. Chair. Mr. Hunter has that right here. It's one big packet, so I'm going to give it to the chair for you to take a look at. We didn't make copies for the entire committee.
Oh.
Well, it was kind of late by the time I got the information, unless we can get copies made. But what we did when we first heard the bill is we added another amendment to the bill prior to this committee, and they will be making yearly reports on what's going on, and Mr. Hunter could talk about his conversation he had with the legislative auditor last week also.
Okay, go ahead, Mr. Hunter.
Well, Mr. Chair, members of the committee, the bill before you, the policy bill, has no fiscal note that I'm aware of. There is a separate appropriations bill that would provide additional funding to the Veterans Defense Project to continue with our education and advocacy efforts statewide with the courts to help roll out this policy bill and ensure that the courts understand it and are properly implementing and using it. That bill is a separate bill that is scheduled, I believe, to go before the House Finance Committee on March 20th. The report that we have, however, for the committee is a copy of the report that we had previously filed with the House Veterans Affairs Committee related to that appropriation bill when it came through that committee. And it outlines how the previous grant funding has been spent over the last 2 years, as well as how any additional grant funding would be spent going forward. We have provided annual reporting to both the House and Senate Veterans Affairs Committee during the 2-year period of our previous grant, as well as providing testimony before the committee. And we have essentially an updated copy of that report that we can distribute with the committee today.
Okay, well, Mr. Hunter, notwithstanding your suggestion that we're not looking at the finance bill, this committee still has questions about it.
Sure.
So my mind would be greatly put at ease if we had an opportunity to look at it and review it, and would like to see that before I had us vote on it. And not having seen it, I guess I'm at a loss for not having been able to see it before we vote, and I have concerns. So what I'd like to do is if we can get copies to the committee and distribute it, Representative Ecklund. We can maybe have a page do it and maybe bring that up when we have an opportunity to review it. And then maybe come back and vote on it. That's what I'd like to do.
Mr. Chair, would that be tonight or at a different time?
I'd like to do it tonight if we can. I mean, normally having to try to review this stuff on the fly and in committee is not really good. But this is your last stop. I don't think you have any other committees to go to after this. Is that right?
I believe that's correct.
Okay. All right. Well, let's do that then. We'll move on to the next House file. We will lay this on the table and bring it back up when committee members have had a chance to review it. Oh, that's right. The chair lays it over is what we'll be doing with House File 998 as amended. Okay, Representative Daudt, are you ready on your bill? Huh? Well, I mean, we could do mine, but. Where is the, one moment, Representative Daudt. My file.
It's behind the, it's all in one package.
Ah, it's in one sleeve. Okay. Okay, House File 1731. Representative Daudt, is there a motion to get House File 1731 before the committee?
So moved.
Chair Scott moves House File 1731. Are there any amendments we have?
Mr. Chair, I have an amendment.
Okay.
And I'm wondering if we could wait until after the testimony, because I may want to remove some parts of this that I had concerns over, but after meeting with the advocates today, may not have those concerns.
Sure.
So if we could wait till
Sure.
afterwards to.
Okay, go ahead. Why don't we speak to that, speak to the amendment first before we take it up?
I think, Mr. Chair, if it's okay, we'd like to just kind of do a quick run through on how the system works, and I think that might help alleviate any questions that the amendment was designed to
That's okay.
Right.
That's okay. Go ahead then.
Is that okay? Yeah, thank you, Mr. Chair.
Yep.
House File 1731 is the veterinary and opioid bill. As you know, we're dealing with, in other committees, the opioid epidemic and putting in place a prescription monitoring program to help make sure that people are not participating in what's commonly referred to as doctor shopping. There's been some pretty high-profile cases in the state and around the country of people doctor shopping their veterinarians as well. Veterinarians prescribe opioids as painkillers for pets, and as we tighten the restrictions on people being able to abuse the human prescription system, we're afraid that people may go to the veterinarians and expose that and exploit that further. So in extreme cases, we also hope that people would not actually injure their animals in an attempt to obtain opioids. So there's been some news stories here locally and pretty high-profile cases of this abuse. So this bill is designed to curb that. What it does is put in place a prescription monitoring program. There is a voluntary system that is in place right now that was created by members of the Minnesota Veterinary Medical Association. Two of them are joining me. To my far right is Dr. Mary Olson. She is actually my veterinarian and a former president of the Veterinary Medical Association. She, as far as I'm concerned, also is a superhero because she removed the cancerous tumor from my dog Daisy's ear last summer. So I certainly appreciate her for that. But over the course of my interactions with her, we got talking about this problem. And have come up with this as a potential solution. Also, closer to my right here, Dr. Jennifer Scherer, and the two of them together have come up with and started an LLC called Vet PMP, and they are running and managing a voluntary prescription monitoring program that this bill hopes that we can make in 2021 a required system for veterinarians to use to track when prescriptions or opioids are being prescribed to animals. So I'll let them introduce themselves and show you the system.
Thank you, Chairman Lesch, for your time this afternoon and the rest of the committee. And as Representative Daudt has already indicated to you, we are well aware of the opioid crisis that exists in the United States, and it is becoming more commonplace.
I'm sorry, could you introduce yourself for the record,
I'm
please?
sorry. I'm Dr. Mary Olson,
Thank you.
East Central Veterinarians and member of the Minnesota Veterinary Medical Association. So as it is becoming more commonplace for us to get phone calls from typically law enforcement saying, do you have this patient coming to you? And we will say yes, and then they say, are you aware that it is getting pain medication for a particular problem from 6 or maybe 8 other veterinarians? Historically, veterinarians have been excluded from the human PMP, and partially that's been because in 2017, veterinarians' prescriptions amounted to 0.34% of those that were filled by pharmacies. That number is skewed some because we can prescribe opioids out of our office at this point in time. We have, last year it became more and more concerning to us that potentially we would be rolled into the human veterinary prescription monitoring program. We're not opposed to doing that, but we can assure you today that it would not stop doctor shopping. That dog right there can come into me as Fifi, it can go down the street as Spot, and it can be Pierre at the third place. And because of the way that the data is entered into the human system, we tried to search one of my known prescriptions in the human system, and it took us about 40 minutes to find the prescription that I knew had existed, that I had written out. So we know that that system, and certainly down the way, it may be able to be remodeled so that we can use one system. But in the meantime, we, along with you, want to stop doctor shopping today or as quickly as possible. So a year ago, we started our own program. It has now been launched as of February. It is called the Vet PMP. It is based on a microchip. So by putting a microchip into each of our patients that may need a prescription longer than 7 days administered by their owners, we are able to track that data under that microchip. In addition to that, our great organization has spent more time trying to educate our veterinarians as far as about doctor shopping and making us be more aware and be better prescribers.
Dr. Olson, if you could
Yes,
wrap
sir.
up your testimony, please.
What's that?
If you could wrap up your testimony.
I am done.
please. Thank you. All right.
Thank you.
Thank you. We have next Dr. Schur.
Hi, my name is Dr. Jennifer Schur. I'm a small animal veterinarian at East Central Veterinarians and have been part of the Vet PMP project. And I was just hoping to take a moment to show how it works. Is that okay?
How long will that take?
Usually under a minute.
Okay, go ahead.
So
We like that in this committee.
comes in. We are,
You have a permit for that?
if we are concerned about, I went to sleep, we can scan it. A microchip is about the size of a grain of rice. If people are interested, I have one inside the keychain you can look at. You have a scanner, you run it over, it beeps, the number comes up. At that point, we put the number into the system, and up comes a pet's prescription information. So for example, this pet, you can see, has had a written prescription for a fentanyl patch sent out the door and has had a prescription dispense, actual tablets from the clinic for phenobarbital, a common anti-seizure medication. The one thing I do want you to take notice is the information in the system does not include client information, and that is on purpose. This is really about tracking what prescriptions that pet is getting so that when this pet goes to the next clinic, even if it goes with a different client or has a different name or a different birth date, we still know the controlled drug history for this pet.
Excellent.
Thanks.
Thank you very much. Any questions for Dr. Schur or Dr. Olson? Go ahead, Representative Lucero.
Thank you, Mr. Chair, and to the doctor. So if I am a pet owner and I, for whatever reason, choose not to want to have this program, my understanding is I would be prohibited then from my pet being prescribed an opioid. What alternatives are there for me so my pet is not in pain?
Dr.
So-
Schur.
Chair Lesch and Representative, we would be looking at other either medical options and or surgical options. So if it is, tramadol has been a popular one recently. If that is not an option because you elect not to enroll, we would be looking at other classes of drugs that are not controlled. We would still want to be able to find treatment options that would take care of the pet that this wouldn't inhibit. So.
Representative Lucero.
Thank you, Mr. Chair. I just want to clarify then there are painkillers available that are not opioids.
Dr. Schur.
Chair Lesch, Representative, yes. There are multiple other classes. Actually, the most commonly prescribed pain class are NSAIDs, which is non-controlled, but there are other classes. There's also other modalities. There's nutraceuticals. There is modifications within the household, and there are surgeries, depending on the condition.
Thank you. Go ahead, Representative Lucero. Okay. Representative Herr.
Thank you, Mr. Chair. Representative Daudt, I just have a couple quick questions, and I don't, maybe your testifiers can answer, but, so like my dog currently has a chip already now, for if my dog gets lost, they can find it. Is it that same chip, or do you have to embed a new chip into the dog?
It can be that same chip.
Dr.
It has-
Olson.
Excuse me.
Go ahead, Dr. Olson.
Chair Lesch. Yes, that can be the same chip. Thank you, Dr.
Representative Herr.
Thank you, Chair Lesch. My second question is that what is the cost? So if my dog is in pain and it doesn't have a chip, what does that cost the owner in order to have a chip embedded so that we can just track the opioids?
Dr. Schur.
Thank you, Chair Lesch and Representative. The cost is a little variable depending on the type of chip that you're planting, specifically the type of registration fees. There are many different levels of registration depending on the brand of chip. But for our system to be successful, registration is not needed, actually. So this is where there are some breed shows have microchip implantation. Our veterinary clinics do. But usually the cost is dependent on the registration fee. I would, if I had to like ballpark it, I'd say most chips get implanted and registered somewhere between 25 to 65.
Representative Herr.
Okay, so I guess, and Chair Lesch, maybe just one follow-up, because I have a hobby farm. I have a lot of animals on my farm. So for me to register all of my animals, if they did, because like right now I'm having a outbreak with my goats. I don't know what's happening with them. But I would, if I needed to get opiates, I'd have to register all 15 of my goats if they were all sick. That's what, is it?
Dr. Scher?
Chair Lesch and Representative, especially when we're talking food animals, we don't use opioids. So,
Well, they're my pets. They're not.
yes. That's going to get into a really controversial. But if there was a condition, especially infectious disease, which is herd-based, that is not where we're reaching for controlled drugs. But let's say someone had 15 senior dogs, then yes, we would need each individual animal chipped.
If, Mr.
Okay.
Mr. Chair, if I
Thank
could
you.
just add on to that.
Representative Daudt.
Thank you, Mr. Chairman and Representative. Just a reminder, in the bill, this is for an opioid that's prescribed for more than 7 days, and you know, hopefully, the most expensive part of this is the registration of the chip. So the registration part wouldn't be required. They just need the chip implanted and be able to read it with the scanner. And we were very conscious of the fact that we don't want to make the cost prohibitive, but knowing that there are other options for painkillers that are not scheduled drugs, you know, we felt comfortable that this is a reasonable way to stop the abuse of the opioids through the veterinarians.
Okay, any other questions? Representative Daudt, I see subdivision 8 here. You're creating an immunity from liability. Representative Olson had a opioid bill. We wouldn't even let it anywhere near this committee with that still in there. So it's not getting out of here with that still in. I'm going to move to remove subdivision 8. You can speak to it if you would like. Go ahead, Dr. Scher.
Thank you, Chair Lesch. So the language that is in this bill for the immunity is the exact same language that is in the human bill that protects human physicians. And so the language was the same because we are addressing the same issue. Veterinarians who participate in the program, we cannot magically prevent what people do with that if we are being good prescribers to the best of our ability. So we are asking for immunity, just like pharmacists and physicians and ophthalmologists have.
Thank you, Dr. Scher. We have a lot of people that come before this committee that are asking to have their liability make them immune from liability, and we take it all very seriously. So, Chair moves that subdivision 8 in total, lines 5.29 to 5.33. Well, wait a second. I guess it would be two lines 6.4. Okay. Be deleted. Any discussion?
Mr. Chair?
Yeah.
Thank you, Mr. Chair. And I had a concern over that too, but because the PMP program that we've had for years here in the state of Minnesota, there's immunity from that. I felt like it was appropriate to have the same language for vets, and I would just ask for consideration of that before we take the vote.
I'm sure you would, Chair Scott, but like I told Representative Olson, she didn't even get in a hearing in here with that same language in her bill. So in the bill for the humans, we said no way. So that's what we're going to be doing on
Mr.
this
Chair?
one too. Chair Scott?
Thank you. My concern is that vets won't use this program then if they're going to be liable in some way for somebody else's actions. And so that's my concern with this, is I want the program to be effective because we have an epidemic on our hands. And so that's why I was asking for the exception.
Understood. Chair Johnson?
Chair Lesch, I also have the same concerns as Representative Scott. I see it's important to have this so we get these pharmacists to participate in this program, because we have situations where we've seen somebody bring one of their pets to multiple different veterinarians and in a very short time period receive 5,000 opioid pills or more. Without this immunity, I don't think the veterinarians are going to participate in the program because there's no value in it. And if they don't participate in it, we're not going to stop the spread of doctor shopping with their pets is easy.
Any other discussion? What? Oh. The motion is to delete lines 5.29 to 6.4. All in favor, say aye. Aye. All opposed, say no.
No.
Motion passes. Anything else on the bill, Representative Daudt? Okay. Representative Lucero.
Thank you, Mr. Chair. And that last line of questioning brought up another question. So back to, I'm reading lines 3.11 through 3.15. Or maybe that's not the right lines, but I read the requirement. So my question is, are there any animals that traditionally don't get an implant now? I don't know, birds, whatever there might be, that would be prohibited from being prescribed controlled substances that now we're moving a category of non-traditionally chipped animals into being required to get chipped?
Dr. Olson?
That does remain a concern of ours, and we are out at this point researching the possibility of that, but have not come up with any animals yet that is a concern on. But I do remain at least a possibility having to return to a different answer on that.
Representative Lucero. Okay. Any other comments or questions to Representative Muller?
Thank you, Mr. Chair. And I just had a question because I know dangerous dogs are required to have a chip too. And so just following up on Representative Herr's question about separate chips, is that still a separate chip or would that still be included?
Dr. Scher.
Nope, any microchip, any of the universal microchips work with this system.
Representative Liebling.
Thank you, Mr. Chair. And this bill is kind of, it's a new thought to me about this aspect of the opioid problem, right? And I just wonder, I get what you're trying to do here. I assume that, I guess there are some people who become addicted and they take their pet to multiple veterinarians with the same complaint. But if somebody's really, first of all, going to the vet is not a cheap enterprise, and there are no public programs that I'm aware of that cover the pet's veterinary bill, so a person will be paying it out of pocket. There's that as a deterrent. But also, I just wonder how effective this is, because if somebody is going to really try to get their opioids from veterinarians, you would think they would just pick up another pet, bring in, it's not that hard to find stray cats and stray dogs and, and bring in just another pet the next time. So I just don't really, I guess I don't have an objection to this being tried, but I just don't really see that this is equivalent to what we do on with the humans, and that it's quite the same thing, since you're really not getting at the pet here. You're trying to get at the human being who's bringing in the pet. And the human being can just easily switch pets. So I don't know, is there anything in there in this that stops a person from, get your sister's dog and get your nephew's cat and, find one on the street and, if you really, this is the way you're going to get your opioids.
Dr. Olson?
Thank you, Chairman. Although that historically has not been a concern to us. It has usually been one person with one pet changing birth dates and names. And again, as that microchip is put in, that would allow them one visit. First of all, there has to be a diagnosis made that would require an opioid to be considered. That's a problematic thing, so it's not just taking in any animal. The diagnosis has to be made, and thus one prescription. And from there has to be a period of time as far as why that prescription would be continued.
Absolutely.
I think
Okay.
that's enough. Thank you.
Thank you. Any other discussion? Representative Herr?
All right, thank you, Chair Lesch. I do have one other question around some of the data. I thought I heard the testimony saying that the information is under the pet's name, but as I'm reading through the prescription, it talks about how between lines 2.17 and 2.30, that you're collecting also the name and the address of the client. I'm assuming that that's the pet owner. And I guess I'm trying to distinguish between what data is data you're keeping and data that's going into this database, and how do we protect that information?
Dr. Scher?
Thank you, Chair. Thank you, Representative. So the section 2.21, that's what has to be in a prescription itself. So that's what goes on the adorable little pill bottles and containers. The only ones that go into this system are 4, which is the drug's name, strength and quantity, 5, the date issued, 6, the directions for use, and 9, the number of authorized refills. That's the information that is tied to the microchip number. All the other stuff is not.
Representative Herr.
That's it. Thank you, Chair Lesch.
Okay, thank you. Any other questions? Chair Johnson.
Chair Lesch, Representative Daudt, I want to thank you. This is, I think, is a good program. Unfortunately, we took a very important part out because veterinarians are the only industry that deals with animals for animal abuse that is not immune from reporting as well. They're immune from somebody using their pet in an abusive way by getting extra and using them to get opioids, but they're also not immune from reporting that to law enforcement if it isn't true. So overall, it's a good bill, but I don't think we made it any better. I think we might have made it worse.
Chair Scott.
Thank you, Mr. Chair. I would like to go ahead and offer the A2 amendment then. And I checked out each of the the things that are being covered in the amendment, and I'm going to just keep the amendment as it is. I think they all still apply. So I'd offer the A2 and ask for member support.
Okay.
And by the way, the meat of this amendment is a Tennyson warning so that the owner of the pet knows that their pet is being enrolled in this program.
Any discussion on the A2 amendment? All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Okay. Any closing comments, Representative Daudt? Thank you. Then the motion was made by Representative Cantrell that House File 1731 as amended be referred to Ways and Means. Yeah. Re-referred to Ways and Means. All in favor signify by saying aye. Aye. All opposed say no. No. Motion passes. Thank you, Representative Daudt. You're on your way to Ways and Means.
Thank you.
I guess let's do Representative Considine. The Omnibus Corrections Data Practices Bill. Is that right? Oh, no. It's the Omnibus Data Practices Bill, but we're here. It's the Omnibus Corrections Bill, but we're here for the data practice. Got it. Okay. I think I got it now. All right. House File 2083, Chair Considine. If you can direct us to which sections we're considering under data practices for this committee. And Chair Considine moves that House File 2083 be amended to be re-referred to the Ways and Means Committee. There are no amendments, is that right, Chair Considine?
I'm sorry, I was reading.
To your bill.
Thank you, Mr. Chair. This is the data privacies of the Corrections Reform Bill. All of these were heard and passed on with very little opposition. I guess we're open for questions.
Okay, any questions? Representative O'Neill.
Mr. Chair, what sections are we considering in this committee?
Let's see, Section 1, mental health screening, 2 through 9, the ombudsman for corrections, 10, the administrative and disciplinary segregation, subdivisions 3, 4, 5, 6, 7, 8, 9. We're going to be removing the removal of data from the system in 11, 12, the intake procedure and mental health screening, 13, the...
When you're saying 13, are these the sections, Chair Considine?
No, these are...
These are your number you have on your sheet.
Okay, let me get my one here. Section 1, the mental health screening, data collection by the sheriff and local corrections agencies. That would be lines 1.13 to lines 1.16. we're going to talk, if anybody wants to talk about the definitions, 2.21. Lines 3.12, subdivision, again, delegation of duties for the ombudsman. Talking line 3.15, powers for the ombudsman, investigation, actions, complaints, and recommendations, down to 3.20, determine the scope and manner of the investigations made. Lines 4.20, actions against the ombudsman. Line 6.14, access to the ombudsman to data. 6.19, publication of recommended reports. 8.27, reporting. 9.10, removal of data from the system. Then down to intake procedure, mental health screening, lines 9.24, and that's it.
Okay, wow. That's certainly a
I'm
step.
sorry, I
Representative O'Neill, any other questions?
Yes, Mr. Chair. So, Chair Considine, when we had this in the Corrections Committee, the Ombudsman bill was very expansive, and I understand that you've narrowed it. Can you just tell this committee what it was and what it is now and how you've narrowed that scope?
Sure, Considine. I mean, I'd prefer that we would speak to just the data practices sections because it is pretty big, but if you can give a brief answer on that.
Well, I believe we did limited some of the scopes on what they can do for subpoenas. Mr. Harder, can you address that for Representative O'Neill?
Who are we talking to?
Robert.
Oh, Harder. I thought you said Carter. I'm like, who's
No.
that? Okay. Sorry. Mr. Harder, did you want to speak to that? I know it's not really not your, I don't know.
Well,
We don't make partisan researchers speak in committee, really,
Okay.
because they're inherently not credible. But I mean, I don't know. Can maybe House Research speak to that?
Sure.
Mr. Chair, members, sorry, I'm not familiar with the bill when it was in the Corrections Committee. I'm only familiar with the data practices provisions that are before the committee now.
Mr. Chair?
Sorry, go ahead, Representative O'Neill.
Thank you, Mr. Chair. So a couple different things that were rather expansive were who the ombudsman had jurisdiction over. And I understand that you narrowed the scope because it was probably hundreds of thousands of folks. There were, it was rather expensive. It was including county jails. It was very, very, very expensive, not just those that are in the prison system. So I'm just wondering if you could first address who did you narrow it down to?
The prison system.
Okay, and then may I continue?
Representative O'Neill, go ahead.
Thank you, Mr. Chair. And then the subpoena power, it had multiple agencies included, and which agencies have you narrowed it down to?
Chair Considine.
To be honest, I'd have to go back and check. I can't answer that question. at the
Okay.
moment.
Is there anyone who can answer that right now?
How-
Or maybe we can move on
research.
until we can get figured. Is research in a position to answer that? Mr. Hopkins?
Sorry, Mr. Chair, Representative O'Neill, could you repeat your question?
Yes, of course, thank you. So in the original bill, he had several agencies that could be subpoenaed for data and information. And I was told that this was now a narrower scope, and there was only maybe one or two agencies now listed as who could be subpoenaed.
Mr. Hopkins?
Okay, Mr. Chair and members, if you look at page 6 of the bill, at lines 14 to line 18, this section, section 7, addresses access by the ombudsman to data. It provides that the ombudsman has access to corrections and detention data and medical data maintained by an agency and classified as private data on individuals or confidential data on individuals when necessary for the ombudsman to perform the powers under section 241.93. So he has access to detention, the ombudsman has access to detention data and medical data maintained by an agency. It doesn't specify an agency, but it does specify that it refers to detention data and medical data, and that the access is limited to what is necessary for the ombudsman to perform the ombudsman's powers under section 241.93.
Representative O'Neill.
Thank you, Mr. Chair. Okay, so thank you. So we've narrowed the scope to just essentially the Department of Corrections, it looks
Second.
like.
Correct.
Representative O'Neill, Mr. Hopkins?
I apologize, members. So also on page 4, lines 5 through 9, the ombudsman does have subpoena power, the power to subpoena any person to appear, give testimony, or produce documents that the ombudsman deems relevant to a matter under inquiry.
Representative O'Neill.
Okay, so thank you, Mr. Chair. That would be a larger pool or a larger scope than I initially, I'm the lead on corrections, that I initially had approved or, agreed with. And so this would still have a very broad scope. So I have some concerns with that area. Didn't realize that was still in here. Also, Mr. Chair, I'd like to know the power of the ombudsman to subpoena. What is if someone doesn't comply with the subpoena, what would be the power of the ombudsman to make them comply?
Okay, who wants to take that question? Chair Considine, you're going to defer to research again.
Research.
Okay, well, I mean, subpoenas are a power of the court, and failure to comply with subpoena is contempt of court. So that would be charged, I guess, in the committee of its local jurisdiction, but if research wants to speak to that, they can do that.
Mr. Chair, members, yes, on line 4.7, you see that the ombudsman can petition the appropriate state court to seek enforcement of the subpoena. So with a state court order, if the person were to not comply with the subpoena, at that point, it would be contempt of court, and they could be subject to fines and other possible penalties.
Okay, if I can, Representative O'Neill, a little bird just told me that an amendment is being drafted to substantially narrow the scope of this. Whether that meets with your approval or not, but I don't know, apparently that's going on, and so I'm getting a, hey, hold on, we're going to fix this kind of thing.
Thank you,
If that
Mr.
makes a difference for you or not, I don't know.
It does, Mr. Chair, because these
Okay.
are discussions that we had offline to try to bring this more in line with what the chair had initially thought that the bill had done, and so I was trying to help him narrow it so it actually did what he thought it did, and I don't think we're quite there.
Okay.
Just in brief.
Understood. Well, maybe, I mean, we're probably going to move it through as is now, but with the expectation that that's going to be worked on an ongoing basis.
Mr. Chair,
Chair Scott, yeah.
thank you. And would that be coming back to our committee then after those changes are made?
No. That's not my plan, unless people really squawk about it, but I want them to fix those because it's a corrections subcommittee issue, and I don't know. If people really insist on it coming back to review that, but you sit on the subcommittee, right, Representative O'Neill?
Yes,
I'd
Mr.
rather not, unless people really make a fuss about
Mr.
it.
Chair.
Chair Considine.
Thank you. Representative O'Neill, I guess I would apologize because I thought it had been done, and I will make sure it gets done before it is in our committee on Wednesday.
Is Representative Liebling.
Thank you, Mr. Chair, and I wonder if I could just shift the conversation a bit. I have a question about, couple questions about Section 12 of the bill, and no surprise there, Mr. Harder. And I just wanted to, we've had a lot of discussion about this, so members, this is about, when a person goes into a jail, that they're screened for mental illness, which is a great thing. We should be screening our inmates, but then that information can be shared with the local county social services agency. And this provision has been around in some different permutations. And Mr. Harder's worked with me to try to narrow this because I had some concerns about it. My concerns had to do with the fact that just because a person's in jail for some reason doesn't necessarily mean that they want their data shared with the county. Some people don't want the county to be in their business, even if they have some kind of an issue for which, that they're screened in jail. Anyway, Mr. Harder's done some considerable work on this, but I just have, and I'm not unhappy about it now, but I just have some questions about how it, what it actually says. So on line 9.29 in that added language, so the names can be shared with the local social services agency, and it says the jail may refer an offender to county personnel of the welfare system as defined in section 13.46, sub 1, paragraph C. That's not, I don't think that's in the bill here, so could you just tell me what that is, or maybe maybe House Research can tell me what that is. I just want to make sure I understand to whom that referral can be made.
Mr. Hopkins?
Mr. Chair and members, sorry, 13.46 is a very big section. Welfare system is a defined term in Chapter 13. It includes the Department of Human Services, local social service agencies, county welfare agencies, county public health agencies, county veteran service agencies, county housing agencies, public licensing agencies, the public authority responsible for child support enforcement, Human Services Board, community mental health boards, state hospitals, state nursing homes, the Ombudsman for Mental Health and Developmental Disabilities, Native American tribes to the extent a tribe provides a service component of the welfare system, and persons, agencies, institutions, organizations, and other entities under contract to any of the above agencies to the extent specified in the contract. So it's a broad definition of the welfare system to include all those components of it.
Representative Liebling?
Thank you, Mr. Chair. And that sounds like a lot. I do want to point out, though, that just, it goes on to say, in order to arrange for services. So I assume that would narrow it a bit, because that's otherwise sounds like a lot of people that it could be shared with. And then secondly, going down to sub C here on line 10.12, and this is what I think Mr. Harder put in there kind of to give me some comfort, because on my thought that if a person, if a person says, okay, I screened in, I have some, anxiety disorder, whatever it is, but I don't want the county to have my data. I was concerned that the county was then keeping that person's data. And so he has put in this section, they have put in this section to destroy it after, destroy the private data if the person doesn't want it used. But, so the little question I have here is, the notwithstanding section 138.17, I just want to know what that is. Would that otherwise would allow the data to be kept? Or maybe, again, House Research can tell me what that is.
Mr. Hopkins?
Mr. Chair, Representative Liebling, members, that's the general statute regarding retention of government data or government records. That statute requires government entities to have a retention schedule that states how long they keep certain kinds of records and what happens to them at the end of that period of time. So because this is calling for a government entity to destroy a record probably before their retention schedule would require them to, we're notwithstanding that section.
Okay, and Mr. Chair,
Chair
thank you
Liebling.
for that, and just, so I just wanted to flag for people that I did have a concern about this, but I am reasonably comfortable with it now, because it really has been narrowed, so that if you're, somebody doesn't want their data kept and just says, I don't want your services, I don't care, I think that counties want to do this with the best of intentions, to try to offer people assistance if they're screened in a jail, and that is something generally that we really do want to have happen. But I just wanted to make sure that if a person doesn't want to be part of that process, that in fact their data will be destroyed. And so that is why that language is in there. Thank you.
Representative Lucero?
Thank you, Mr. Chair. I'm trying to cross-reference and listen to the conversations at the same time. Could I get clarification on what Mr. Hopkins just referenced? Was he referencing, I'm looking at section 7, which is line 6.14 through 6.18. And the answer that Mr. Hopkins just gave, was that in regards to chapter 13, which is referenced there?
Mr. Hopkins?
I apologize, Representative Lucero. I just read I just discussed at page 10, line 12, the cross-reference to section 138.17. That's the 138.17 is the statute regarding retention schedules.
Representative Lucero?
Okay, thank you, Mr. Chair. Then my question, I guess, would be for the bill author or the bill author in regards to this section, and it was brought up by somebody a couple questioners ago, which is the word access and then the word an agency. So an agency can have access, but that doesn't look like it's narrowed at all. And then what concerns me is the word notwithstanding, that it makes a reference to those two citations there for Chapter 13, and then has access. So what does access mean in the context of somebody doing their daily duties here? Because it says they have access to it in order to perform the powers under Section 241.93. So does that mean that they're looking at a system, viewing data, but they can't take it with them? Does it mean they're downloading that data onto a laptop, for example? Or does it mean that they have hard copies of corrections, detention, and medical data? So what does access mean?
Who are you asking that of?
Bill author.
Okay, go ahead, Chair Considine.
I believe they're trying to line the person up with mental health services so they can improve their life. Now, as far as each and every one of those things, I don't have a clue.
Representative Lucero.
Okay, thank you, Mr. Chair. And that's what makes this difficult, is just cross-references all over the place, and then when you have it leading with the word notwithstanding, I'm just concerned about that because the language access is vague, agency is vague, and then I don't know what the retention is. I don't know what the, in order to perform their duties, are they going to be destroying it? How are they going to be protecting it if they're copying it to the local machine? In my mind, what I'm envisioning is something like a public defender, right? A public defender has information on those that they're defending, and they're carrying it around with them. So as an, I'm going to screw the word up.
Ombudsman.
I won't say it, but there it is. Are they similarly carrying this information around, and how is it being protected? That's my only concern. No question, Mr. Chair, but just throwing it out there for the committee to consider. Thank you.
Thank you. Chair Johnson.
Chair left, Representative Considine, you mentioned at the beginning that this was refined down just to the state correction system.
Correct.
Then I have a concern on lines 5.19 through 5.23. Investigations of adult local jails and detention facility. That's putting the ombudsman into the county system, the county jail system, the local jail system. Giving them inspection, or the jail inspection unit or the Department of Corrections may investigate complaints involving local and adult jail and detention facility.
And that will be dealt with
Chair
the
Considine.
amendment that we're going to bring.
Chair Johnson.
I guess, okay, as long as it's dealt with, I'm fine. Otherwise, we do need to hear this because it does affect our local tax dollars, because our sheriffs do a very good job in their facilities, making sure everything is done right. Overall, there's some things with the mental health issues that are good, but we just got to make sure that we don't strain our local facilities too bad.
Chair Scott.
Thank you, Mr. Chair. And I wanted to address 614 through 618 as well. And I'm more than happy to work with Chair Considine to tighten up this language, but there are several issues with this language. Access, as Representative Lucero brought. Agency is really broad. Is that the Department of Health? Is that a county agency? We just don't know. And the whole issue of accessing medical data, to me, is concerning. And regardless of which agency these people, their data is held in, if it's medical data, they should have the right to give permission for it to be seen or not seen. And so I think there's a lot of problems with 614 through 618, and I'm more than glad to work with Chair Considine to button that up, Mr. Chair.
Thank you. Okay, seeing no other comments, Chair Considine, closing remarks?
No, Mr. Chair.
Okay. Well, when you fix that, I guess we'll make the call as to whether or not it needs to come back here based on the fixes. Chair Johnson.
Chair Lesch, I just wonder if there's anybody in the audience. We do have quite a few people out there who might want to speak on some of the issues we have here as well.
Do you all want to speak on the data practice bill on corrections? Mr. Newmeister, come on up.
Mr. Chairman, members of the committee, for the record, my name is Rich Newmeister. I gladly, wholly support this bill. and the data practices provisions in it. Now, the bill is limited, and so be it. But to let you know, I've worked a lot with the Ombudsman's office historically, when it was under John Pupar and T. Williams. Beatrice Williams was the first ombudsman. In 2003, it was zeroed out. And there was a task force that was done in 2004, 2005, that basically said, under the human rights, and basically said, maybe we need to take a look at that again. And I'm glad that it's before you. Now, even in its limited format, I think it's still a good deal. It should be going to the sheriffs, which historically they were for almost 30 years before it was zeroed out. Now, on the data practices provision of the law, now, 614 through 618, I think it's okay. Why this provision of law is important? It's important for the ombudsman to be able to do their job. If they can't do their job, then why are we doing it? This provision, I think, if I remember right, and from the language I remember from the ombudsman proposal, this may mirror that same language. If you look at, so I think it's very similar to what the ombudsman classification was from before. So I have no problem with that. Then the other item I'd like to make comment on is on
You could
lines
keep it brief, Mr.
929.
Neumeister,
Pardon me?
if you could keep it brief.
Yeah. The question I have is names of persons who have screened positive. Now, the screening tool that is used by law enforcement and the sheriffs is basically, I think there's 10 questions asked. And 4 out of 5 or 4 or 5 out of the 10, you become labeled as possibly as someone who may have a mental illness. I have a concern about that. And particularly when it's done in the jail. Many times it's done within just a short period of time. There could be someone, very rowdy or whatever. So when you're using a screening device, and then at the same time where that information is going out, hey, Jane or Joe was screened positive as possibly mentally ill, I have some concerns about that. And on the latter part, if the data is destroyed after 15 days, the question that I've always asked over the years when I see that, who's going to enforce it? So, Mr. Chairman, members of the committee, those are my points.
Thank you very much. Thank you for your testimony, Mr. Neumeister. Any other comments from the committee before we move on this? Representative Lucero.
Thank you, Mr. Chair. Just real quick, so Mr. Hopkins came up and he mentioned to me that within what Mr. Neumeister just referenced, those lines 6.14 through 6.18 that Mr. Neumeister said he didn't have a problem with, well, again, that didn't provide any comfort to me. I still have a concern. And so I echo the remarks of Representative Scott to work on the amendment language. But Mr. Hopkins mentioned that that's a date of classification and those aren't handling procedures. And so access, I think Mr. Neumeister would have a concern. Since access is very vague here, it could mean that somebody downloads information to their laptop. The laptop is unencrypted since there's no handling procedures here. The laptop is stolen out of the back seat of the car and it contains medical data. So I think a greater concern should be given consideration. Thank you.
Thank you, Representative Lucero. Any other comments? Okay, seeing none, then, Chair Mariani.
Mr. Chair, I just want to make sure that whatever we do here, we don't wind up stalling Chair Considine's bill. I certainly am convinced by the arguments that members have made here about the need to narrow down the scope. I think Chair Considine probably agrees with that as well in terms of the data privacy issues. And I will gladly, in our committee, when we mark up the corrections component, incorporate that as amendments. I obviously would look for advice from members that have, echoed, I think, some very important concerns here. But I certainly don't want to lose the broad scope and thrust of what Chair Considine has in this bill over agreement, frankly, but, just bad timing here in terms of the need to narrow down the data privacy concerns.
Thank you. I appreciate that. Representative O'Neill.
Thank you, Mr. Chair. Just really quick to that point. I think that the reason that it needs to be narrowed is, one, a fiscal impact, because initially the bill had the ombudsman looking over literally anyone that was in the criminal justice system. It was very, very, very broad. It was juvenile detention centers. It was anyone in a county jail. I mean, it was hundreds of thousands of people. But I think the intent of the author was really to keep it just in the prison system. So the 10, 11 prisons that we have, 11 prisons on 10 sites. So in our attempt to try to bring down the scope that was just rather broad, that was the conversation that we had, and I hope we can continue that it really is what the author had intended, what the chair had intended initially, which was to bring back the ombudsman for those detained within corrections, within the DOC, within the walls of, the 10,000 that are within the walls of the prisons right now. So if you want to do something broader, it dramatically increases the scope and it dramatically increases the cost. So just to be aware of that.
Thank you. Okay. Seeing no other discussion, that it is the intent with the understanding of what has been raised already so far, is that the bill will be moved and referred to Ways and Means, that expectation that it gets worked on. Chair Considine, closing comments.
Yeah, I just want to say actually thank you to the committee as a whole. I think there's been a broad recognition that the ombudsman position is important. And actually, there's been a lot of good comments from both sides, and I appreciate the effort to make it better and workable. So, yeah, we need to do a little better. I need to do a little bit better on the data privacy, and we will get that taken care of. Thank you.
Chair Considine's motion is that the bill be referred to Ways and Means. All in favor signify by saying aye. Aye. All opposed say no. No. Motion passes. Thank you. Representative Ecklund, can you come down? Members, after this, we will move on to the bill that a lot of people are hanging around for, which is the forfeiture bill. Representative Ecklund, members of the committee have been passed out, I think it's a 19-page document. My question for you is there, I thought the request was, how did it spend its money? How did the Veterans Defense Project spend its money? And there are introduction, but I don't see any numbers in here. Can you point out to where in this document is the number about how the money was spent in the past, what it got us? And let me just, for background, explain this. I've been a member of this committee in one version or another for 13 years now. And it's not, with the money that this legislature appropriates, a very, very small amount is given out to specific groups, specific private groups. Everything else goes to an agency or an agency to distribute through whatever process. Most often through, when we were public safety, it was OJP. OJP would get a bunch of money, and then they would distribute to groups based on those requests or RFPs or whatever. Once in a while, this committee would get into fights because a member would want to earmark a certain amount to a group, and it was what it was. But when we did do that, there was a lot of discussion about how it got spent, what we got for it, what we did. And in this case, there has been a lot of testimony about how veterans courts are underfunded throughout the state. We don't have them throughout the state. And so we should be prioritizing that. And we're not prioritizing it as much. That should be something that comes out of this committee's budget, but it's something that we want your group to do if we pass the bill. So my thought was that, okay, we would see something of how the money was spent, and unless I'm mistaken, I don't see that in here. Can you point to where it is in here?
I can't.
Mr. Hunter.
Well, Mr. Chair, first off, when you and I talked about it on the House floor, I misunderstood you, and I apologize for that. The documents that you're talking about were turned over last week to the legislative auditor because they had the same questions. And right now, the funding has gone through humanities, and that's who's these. And I can let Brock explain further how that goes. But the last appropriation was through the humanities. They're the fiscal agent for this project. and then Mr. Hunter has been working through that group, and I can let him explain how that happened. But we did not bring the financial statements that you were asking for because this is a policy bill. Representative Jay Zhang is carrying the finance bill, so I just apologize for the misunderstanding.
Well, thank you, Representative Ecklund. I want to be as helpful as I can, but questions have been raised, and I feel obligated to do my due diligence, not on all of them, but on the area that I think this committee should care about, which is, hey, we're not spending money on veterans courts. We want to give the money to the Veterans Defense Project. So what have they done and what are they going to do? I think that's a fair question to ask. So yeah, I would like the financials. And, you know, I think I can safely say that's our intent to make sure that your bill meets deadline, Representative Ecklund, but I'm not comfortable with having this forward with us without those numbers in. So why don't you get those numbers out to the committee, get the financials to the committee so that we can review them as soon as possible, and we'll get you in and out of here before deadlines.
Mr. Chair, I will have those numbers emailed to you tomorrow and make sure the rest, and the committee administrator, and make sure that the numbers are distributed.
Thank you. I appreciate the accommodation. Thank you, Representative Ecklund.
Mr. Chair?
Yeah, Representative O'Neill.
Thank you, Mr. Chair. And I would just ask that they would be fairly detailed. I think that it's important not to just have some big, large overview of the financials, but in some level of detail so that we can take a good look at it and see where the money is really going. Thank you.
I think that's fair, and that's a fair point, Representative Ecklund. It would be, you know, I guess my expectation is on the boards that I sit on, we get, you know, we get the 990s, we get the, you know, whatever budget, that kind of thing, which I can't imagine is that controversial. But thank you for that point, Representative O'Neill.
Thank you, Mr. Chair. It would be very helpful.
Representative Muller.
Yeah, thank you, Mr. Chair. And just another point, too, that maybe we can consider when it comes back again. House research indicated that there's a better way, the oral amendment that we had, to make it even clearer than how we actually amended it. So if we can maybe take care of that tomorrow, too, that would, or the next time we meet, that would be great.
Oh, but the change in the B to the A and the striking it?
That's right, yeah.
Okay, so we'd
we'd
have another shot at that. And that's all consistent with the expectations that the prosecutors wanted in this. Is that right, Representative Ecklund?
Mr. Chair, that's correct.
Okay, thank you. And it's not my intent to have you keep coming back on this. You've been back, this is your I don't know how many times, but it's enough. And maybe we can talk after this just to make sure that next stop's going to be the last one.
Thank you, Mr. Chair.
Thanks, Representative Ecklund. Okay, moving on to the forfeiture bill. Representative Muller is going to take the gavel.
All right, members, the next bill we have up for consideration is House File 1971, Forfeiture Bill. Chair Lesch, would you like to move your bill?
I would, Madam Chair.
Chair Lesch moves House File 1971 be recommended to be re-referred to the Ways and Means Committee. And Chair Lesch, you do have an amendment, is that correct?
Well, Madam Chair, yes, but I think the decision I've made, I haven't told them that we're not going to offer it. Because it's my expectation that this bill should not have to go to Environment Finance. All the conversations that we've talked about are conversations regarding licensed peace officers, which are the prerogative of this committee. If I'm wrong about that, we will get a hearing in Environment Finance to make sure this meets deadlines. It's my contention that the effort to move this to Environment Finance was an opposition maneuver that I think is unnecessary. So we'll get that cleared up, and it's my intention to not offer that amendment right now with the expectation that this bill will meet deadlines.
And so, Chair Lesch, just to be clear, that's the A1 amendment that you're not offering. Is that right?
That's
A1?
correct. That's the A1 amendment.
All right, so then we've got House File 1971. If you want to go ahead and tell us about your bill, please.
Thank you, Madam Chair. Members, some of the biggest black eyes that the state of Minnesota government has suffered during the time that I've been in the legislature have been due to abuses of the forfeiture process. Folks may recall the infamous news articles relating to the gang strike force about 12 years ago, as well as the drug task forces. Further, there are methods used by law enforcement that are egregious overreaches of the criminal justice system, in that the system is designed to exact justice from individual defendants accused of a crime or even not accused of a crime, and the punishment should fit the crime. And what forfeiture has been used as in Minnesota and in many other jurisdictions has been a way to supplement punishment while having a dedicated funding source to law enforcement agencies whose job it is to enforce that. Now, let me restate that. There is no reason, no good reason for a government agency to fund itself through its own enforcement powers. That is a recipe for disaster. It is a recipe for graft. It is a recipe for corruption. It's the kind of thing that you see on the East Coast, which we in Minnesota have been relatively insulated from for quite a few years in the history of our state. And no one is saying that Minnesota should end forfeiture, right? It is a legitimate process. But the bill is a process bill, so it does not end forfeiture. Instead, it establishes a new process as to how the state is going to confiscate the fruit and the instruments of crime. This bill ends the civil forfeiture process and replaces it with a criminal forfeiture process. That means that in order to get your stuff, they have to get a conviction against you. They cannot start dual processes and take your stuff, and then we'll worry about maybe convicting you later. And members know, some of you members know that in the time that I've gone into private practice, I've represented several indigent individuals in forfeiture procedures. And Ruben Rosario, a columnist for the Pioneer Press, wrote about one a few years ago where a client of mine who was very low income had a boyfriend who drove her car to pick up or to drop off rent money. And that vehicle was stopped because he disobeyed a traffic light. Her boyfriend had an individual in the car with him who he was giving a ride to, who had a little vial of cough syrup with him. When they were stopped, the passenger fled the scene and left this vial of cough syrup as well. And this is all a matter of public record of the fleeing of the scene. The police department seized the vehicle, seized the rent money, pending the testing of this vial to determine whether it was illegal amounts of codeine or not illegal amounts of codeine. Ultimately, this had occurred in February of a few years ago. It was not until September that the Bureau of Criminal Apprehension finally determined that it was not an illegal controlled substance in that vial. So this was at least 8 months later that they were holding her car. Meanwhile, she lost her home because that rent money meant she couldn't pay her March rent. And so she was kicked out of her home. She didn't have a car, so she was homeless and she was carless, and she was trying to hop from different people's couches back and forth. She had a 4-year-old child at the same time. She lost her home and she lost her job because of that. It was not until almost a year later that Ramsey County finally conceded they had no reason to seize this vehicle. Meanwhile, all the damage had been done. This is a result of civil forfeiture. And this perpetrates, in my opinion, a crime against the people of the state of Minnesota who do not have the resources to fight back. So this file builds on the patient-involving step-by-step and pragmatic approach in which we've engaged to protect Minnesotans' rights for 9 years. We started in 2010 working with the Department of Public Safety shutting down the scandal-ridden Metro Gang strike force. A year earlier, the strike force collapsed because it misplaced evidence, mishandled funds, and raided people's homes where property was seized improperly. And members, this also happens when there were no arrests effectuated. Seizures occurred of cash and property in public without any criminal proceedings proceeding or even intended to be criminal proceedings intended to be initiated. So this is walking around old school, just like you'd see, actually taking money and property from people. So the members of the strike force use the laws to extort cash and property, particularly from those without access to attorneys or were concerned about their immigration status, people who were not in a position to fight back and assert their rights. 3 years later, a federal judge awarded $840,000 to 96 victims of illegal seizures by the Metro Gang strike force. Since 2010, this committee has debated forfeiture legislation every single year. These annual efforts were bipartisan. They occurred when Representative Paymar and Representative Scott chaired this committee. So in other words, we know this well. In fact, we helped enact at least 5 bills. There were reporting requirements 2010. There was a forfeiture of property related to sex trafficking in 2013. The prerequisite of a criminal conviction for those who file a civil complaint came in 2014. And the forfeiture of property related to the crime of exploiting vulnerable adults in 2015. The process for spouses, parents, and their other innocent owners getting into court in 2017. This was, that was Representative O'Neill's bill. That's right. Some of these bills were co-authored by Representative Considine, Liebling, Lucero, Scott, and myself. So we recognize that much of this bill consolidates existing law into a new section. So on the background, we turn to the bill and address the 2 remaining issues. First, the current civil forfeiture process for litigating the transfer of title. It does not protect enough Minnesotans. It is the wrong process. We can and should do better. Specifically, we should replace the civil process with the criminal forfeiture processes in this bill. And the criminal forfeiture is the process Minnesotans are due, because that's the entire basis of why you're taking this stuff, because this property was used as the instrumentality of a crime. That's the entire point, and that should be how it's reflected in law. So under criminal forfeiture, even those who have small amounts of cash and property taken from them will have their day in court, and they'll get their property back if they're not charged or convicted of a crime. This is important because the average forfeiture in Minnesota is not hundreds of thousands of dollars wrapped in plastic, but $1,459. That's rent money, folks. A lot of people will have this rent money, and it's gone when that's taken. And by the time you go through the process, they can't get it back anyway because they've already been evicted. 94% of the cases are below $5,000. Of the 8,000 cases that occur annually, Minnesotans walk away from their property about 95% of the time. They don't even challenge it because they know they can't fight the system. Walking away seems to me to be the rational response in today's law. It is irrational for a property owner to hire a defense attorney and file documents within the short window of 60 days to try to get back $1,459. In most cases, I would advise a client not to pursue that case in civil court. And members, that I have advised clients to not do that. They would be paying me too much. It wouldn't be worth my time or their time. Secondly, the bill addresses who keeps the forfeited proceeds, and this is the bill's core issue. Our predecessors in the legislature abdicated control of the purse. In 1971, we authorized law enforcement to keep forfeited proceeds. And this is one of the major problems. It means you police for profit. It's a bad way to fund. I don't know a single person, and you know what, I'll buy anyone a pizza if they come up here and say that for a law enforcement funding themselves by taking people's stuff is a good way to do law enforcement. If law enforcement is honest, they'll say, listen, we need this money to do law enforcement. And that's accurate. That's true, and that's fair, and we should fund them, absolutely. We should make law enforcement whole. But I have yet to meet a person who thinks this is a good way to prosecute folks and enforce the law. The law is horribly flawed because it allows the executive branch to control both the sword and the purse. This is a problem for another reason. At minimum, self-funding by the executive branch creates the perception that police and prosecutors have that financial incentive. We should adequately fund law enforcement to do this, but the proper process is through our budgeting mechanisms. Mr. McGrath is here to explain how the bill addresses these two bills' remaining problems. Many of you know Mr. McGrath. He's worked on this issue since 2010 with me. He is with the Institute for Justice and has litigated the forfeiture case in Timms v. Indiana, in which the U.S. Supreme Court ruled in 9-0 last month in favor of the firm's client, Tyson Timms. Mr. McGrath.
Welcome to the committee, Mr. McGrath. Please introduce yourself, and you can begin with your testimony.
Madam Chairman Lesch, members of the committee, my name is Lee McGrath. I'm the Senior Legislative Counsel for the Institute for Justice. My colleague Wesley Houghton argued that case a few months ago, and we're pleased that the Supreme Court has put on the table some constitutional questions. Madam Chair, members, crime should not pay. It is a legitimate function for government to confiscate the fruit and the instruments of crime when a person has been convicted and the prosecutor shows that the fruit and instruments are linked to that crime for which he was convicted. This bill is very similar to the bill that Representative Knobloch and Representative Omar authored last year, but it is cleaner. We've listened to some of the objections that we got from last year, and we clarified that there are three different types of property owners. There is the suspect, there is his spouse, parent, or neighbor, innocent owner claimant, and then there is the creditor. And so one of the differences in response to criticism that we received is to clarify each of those different types of property owners and give them an individualized process for them to go into court. Let me just point out, Mr. Chair Lesch, if you'd like me to, I'll point out some key aspects of the bill.
Please do.
On page 6, on line 6.11, this is one of the very, very, very few changes that we make to the seizure process. Most of this bill does not deal with the work of police officers and sheriffs as it relates to on the street taking possession. Most of this bill relates to the work of prosecutors in courtrooms and in their offices. But one exception to that general theme is that this bill goes to address some of the problems that exist with that low dollar amount that Chair Lesch talked about. And it exempts, on line 6.11, from both seizure and forfeiture $300 in cash, something that Hennepin County already does, and motor vehicles of less than $2,500. Representative O'Neill is left. I would point out that in Knobloch's bill last year, those numbers were bigger, 510,000. Moving on then to what happens when you change from a world of civil forfeiture and criminal prosecution to one world in which the criminal prosecution is followed by questions of property. That is on page 7, and there you see on line 7.5 that this bill ends civil forfeiture under this chapter and creates a single, efficient process of requiring a criminal conviction. Now, importantly, we're not blind or overly ideological about this. There are real exceptions to this criminal prosecution. We note on line 7.10 that one of the ways in which a conviction can be met is through a plea agreement. And experienced litigators in this room know that a large percentage of cases are ended by plea agreement. Additionally, on line 7.16, we're equally pragmatic in terms of ways in which the obligation to get a criminal conviction disappears. So whether the suspect dies, whether he's granted immunity, whether he flees the jurisdiction or abandons the property, it's impossible to get a criminal conviction in those circumstances, and this bill pragmatically allows for that. On the next page, on page 8.18, here we have built on some of the work to clean up processes. On line 8.18, we develop a system of one single complaint. The criminal complaint, it has charges against the person, it has charges against the property. Madam Chair, flipping to page 10.8, page 10, line 10.8. This establishes one of the processes that is needed for getting into court early. The Crimstock case in the Second Circuit, a decision in the federal courts in Indiana, and a case currently before the Minnesota Supreme Court all deal with this issue of getting into court promptly, and this Replevin hearing facilitates that. On the next page, on page 11, line 11.7, this deals with the Timms case, my colleague's case, the question of proportionality. And this goes as far as a legislature can go. It is beyond the authority of the legislature. It is a violation of the separation of powers for the legislature to tell a court how to interpret a constitution, how to interpret the Constitution. That is solely a function of the courts. But this bill goes to the line and says what the courts can consider. And we feel this is where the line should be drawn. On page 12, you can see at the top of the page, line 12.1, we facilitate the ways in which credit unions and S&Ls and other banks can get back their collateral. On page, further down that page, on line 12.12, we build upon the existing innocent owner process that exists in Minnesota. But to Chair Lesch's experience, we do an important thing here is that we flip the burden of proof to the government. We think the burden should be on the government and not the spouse or parent. On page 14, on line 14.3, we allow for prosecutors to find substitute assets. If the defendant has hidden the assets or dissipated the assets, prosecutors should be allowed to go after other assets, and that's facilitated in that section. And then finally, not finally, one before finally, Madam Chair, on page 15, line 15.7, to Representative Lesch, Chair Lesch's point about separating the purse and the sword, this is where we do it. On line first, on line 15.16, the court may order funds to go to that specific victim who's been victimized by the crime. Secondly, on line 15.17, the court may order law enforcement to receive reimbursement for non-personnel expenses. And then thirdly, on lines 15 through 19 through 15.24, the court orders that the funds be transferred equally to a series of neutral funds so as to overcome the perception of conflicts of interest. Finally, Madam Chair, and this is the final point, it is essential if you are going to reform Minnesota's law that you close the back door. You cannot let these processes be outsourced to the federal government. You do not want to be Missouri. You do not want to have a beautiful state forfeiture law and then have 82% of your forfeiture dollars be outsourced to the federal government. And so this bill closes partially that back door. It does it by by prohibiting the thing that Attorney General Holder prohibited on line 15.25, but Attorney General Sessions revived. And then it puts a limit on how much, where the prosecution goes on the smaller seizures associated with joint task forces. It is a comprehensive bill, Madam Chair, that builds on the work that has been done for a long time in this committee as well as in other states. I'd be happy to answer any questions about the bill.
Thank you, Mr. McGrath. I think what we're going to do first is take all testimony from the proponents of the bill. Then we'll ask questions at that point, if you don't mind sticking around. And then we'll hear from those opposed to the bill and do the same thing. Is that all right with members? Okay, sounds good. So our next testifier, Chair Lesch, who would you like to be up next?
Whoever's closest, Madam Chair.
Okay. Hi, welcome to the committee. Please introduce yourself and you can begin.
Thank you, Madam Chair. Members of the committee, my name is John Gordon. I'm the Executive Director of the American Civil Liberties Union of Minnesota. I appreciate the opportunity to be here today and to remind us all that civil asset forfeitures impose crushing debt on the most vulnerable members of our community. Faced with general fund shortfalls, state and local governments have used forfeitures to balance budgets, seizing assets worth far more than the penalties imposed by the criminal justice system, all that at the expense of individuals, some of whom are never convicted of a crime, and many of whom can least afford it. These burdens fall disproportionately on low-income individuals and people of color. Using forfeitures to fund general government services also skews incentives, as I'm about to demonstrate, in the criminal justice system, prioritizing short-term revenues over public trust and safety. It turns out, Madam Chair and members of the committee, that 96% of the forfeiture proceedings in the state of Minnesota are administrative and therefore untouched by the 2014 law that Chair Lesch mentioned before, making a criminal conviction a prerequisite to judicial forfeiture. So 96% of these forfeitures are unaffected by any of the criminal law protections that people get in those proceedings. In the Timms case that Mr. McGrath's colleagues so successfully won in the Supreme Court, the Supreme Court of the United States pointed out that these abuses have been going on literally for centuries. And for centuries, they have been burdening the people who can least protect themselves against the system. The Supreme Court also noted that revenue from these sources can skew incentives and result in burdens that are out of alignment with the burden of the criminal law. And the Timms case was a great example of that, where the forfeited property vastly exceeded any potential criminal penalty. So the people who are least able to bear these burdens and to protect themselves against government overreach are low-income individuals and people of color. These communities are both more likely to have property seized and more vulnerable to the downstream consequences of these forfeitures. For example, cash forfeitures, which represent approximately 25% of forfeitures in Minnesota. So that's where money or currency is being taken as opposed to cars or property or whatever. Cash forfeiture disproportionately affects low-income Black and Hispanic households, who are 5 times more likely to be unbanked than white households, according to the FDIC. So unbanked individuals, that is people who don't have access to commercial banks, checking accounts, savings accounts, tend to frequently use cash in their daily activities the way that many people with more money don't have to do, because they've got access to banks and credit cards and all those sorts of things that people are used to, and which are much harder to seize. And so there are people who literally have money that is taken away from them, as has been pointed out, that they need to pay the rent. So it turns out that once assets have been seized, low-income Black and Hispanic households tend to have less access to credit to help withstand the loss. That is, they can't even go borrow the money to get them through tough times. More than 67% of Black and 63% of Hispanic households making less than $15,000 have no mainstream credit at all, compared to only 48% of white households. So you've got this huge racial disparity. looking across incomes, only 8.5% of white households making $50,000 to $75,000 lack mainstream credit, compared to 18% of black or Hispanic households, 8% white, 18% of people of color. And the interesting statistic that the average forfeiture is $1,459, as was said. It turns out that of people, all the people in the country, 58% of all the people in the country have savings of less than $1,000. So for 58% of the people, a forfeiture of $1,459 literally wipes them out. That's why the collateral consequences of law enforcement seizing cash that is meant for bills or seizing a household's sole vehicle for getting to work, the collateral consequences quickly overwhelm families. So even while a property owner is presumed innocent of a crime in the criminal justice system, so a seizure that would be manageable for a person of higher income becomes an insurmountable source of financial instability and stress for those who cannot make up the loss, ultimately undermining the deterrent and rehabilitation purposes of the criminal justice system. Finally, focus on revenue collection can harm public trust in law enforcement and make us less safe. Speaking of Missouri, by the way, Ferguson, Missouri, which became infamous as a result of not just the killing of Michael Brown, but the Justice Department investigation of their policing for profit system. If you read the Justice Department's report on policing in Ferguson, Missouri, it is something that is absolutely chilling and something that we in Minnesota, frankly, can do a lot better on. So the incentives that are created by policing for profit, which is exactly the incentives that are inherent in the forfeiture system, are something that we in Minnesota should not want to have anything to do with. That's why I am very pleased and proud to support House File number 1971, which we think should be an important step forward in this state and help us to be a leader in the country. Thank you, Madam Chair.
Thank you, Mr. Gordon. Whoever wants to come up next, please come on up and introduce yourself, and you can begin.
Madam Chair, members of the committee, my name is Jason Flores. I'm the State Director for Americans for Prosperity, Minnesota. And on behalf of our activists across the state, I want to urge you to pass House File 1971, which would protect innocent property owners in Minnesota from losing their property by replacing civil forfeiture with criminal forfeiture. Now, much of my comments have already been made by other testifiers. I'm going to keep it brief on behalf of everyone here, so I'm going to try to condense my comment a little bit.
Thank you, Mr. Flores.
Of course. Simply put, Minnesota property owners lack protections here that residents of many other states take for granted. Chairman Lesch vividly outlined the impacts of the current law on many families and talked about the very onerous process and the barriers that government has put up to getting that property back. When 95% of forfeitures result in an administrative forfeiture, where people don't even try, it's not even worth their money to get that property back, that's exactly the opposite of the innocent until proven guilty standard that applies throughout our criminal justice system. Under House File 1971, some of the good work that was done since 2014 is expanded upon. It creates, or that two-track system that was created is closed and now requires that both property owners and property are tried in the same criminal case and would prohibit forfeitures from taking place without a conviction. For too long, our forfeiture laws have violated our very constitutional right to due process. Government should respect and protect our personal property, not seize it, and then force citizens to file suit to prove their own innocence in what's oftentimes a second trial just in order to get their property back. This bill would ensure that innocent property owners in Minnesota regain their fundamental liberties by making a long overdue change to a constitutionally dubious policy. Americans for Prosperity fully supports this bill. We urge its swift passage in the legislature. Thank you so much for your time tonight, members of the committee, Madam Chair.
Thank you very much, Mr. Flores. Mr. Kohler? Welcome to the committee. Please introduce yourself and you can begin.
Thank you, Madam Chair, Chairman Lesch, members of the committee. My name is Dan Kohler. I'm a member and on the board of directors for the Minnesota Association of Criminal Defense Lawyers, testifying in my capacity as being on that board. Also, as a private defense attorney, I was counsel and still am counsel for both Helen and Megan Olson. Their case is currently pending before the Minnesota Supreme Court, testifying absolutely in support of this bill. I'm going to keep my comments even shorter than I anticipated because I do think a lot of ground has been covered. But there's a lot of aspects about this bill that are correcting things that have been a problem for a long time, and this is absolutely the right time for this body to be acting on this. Minnesota's forfeiture laws are going to look like Swiss cheese pretty soon because it's been so long in the coming that we're getting all of these constitutional challenges to the procedures that have been sitting around for decades, and they're all unconstitutional. And fixing it now, the optics are good, you're future-proofing our forfeiture laws so we can continue to go forward with forfeitures, but do it in a just way. Some of the other problems that come up in situations like this, like Chairman Lesch said, I've turned people away. I've said it's not worth hiring me for this forfeiture. The value is not worth it. You can't have that much sentimental value for your 1994 Honda Civic. And it's right, so they're going to lose their vehicle. But there's the cases that I take pro bono. And even then, the relief I can give them under the current law is limited. I've got a true blue innocent owner, and I say, yep, I'll take your case for free. Let's get your car back. I tell them right off the bat, minimum 120 days before I can get your car back. And that's if everything goes right. Minimum 120 days before we get that cash back. And that's if everything goes right. And then you've got all of the people that come to me and I have to tell them, I'm sorry. Like, you absolutely got a case. They should not have taken your property. But we had 60 days to file a petition, and it's been 3 months. And we know the criminal justice system is plagued and driven by people that are suffering from addiction, suffering from mental health issues. Those are not the type of people that are going to read the fine print on these forfeiture notices. These are not the type of people that are going to think that they've got this deadline to get their property. The current law is wronging a lot of people. It's hurting the wrong people. And this is the best version of this bill that I've seen, and it corrects vast majority of those inequities. It was last year that I was testifying before this committee on the eve of the Olson decision coming out of the Court of Appeals. And I said, I don't know what's going to happen, but you guys might need to act on this. And I'm doing it again this year, knowing Olson could be coming out any day, striking down significant portions of the current law. And I'm not just a defense attorney. Like, I live in Minnesota. I would love for us to have a comprehensive just forfeiture law in place that I'm not raising constitutional challenges to. And I think this one fits the bill. And that's why, personally and on behalf of MACDL, I'm asking this committee to pass this bill. I think it's a good bill. Thank you.
All right, thanks. So at this point, I think what we'll do is we'll open it up to member questions. Do we have anybody who wants to start? Okay, I have a couple for Mr. McGrath. Just going back to a couple of the lines you mentioned, page 7, line 7.20, fled state jurisdiction. Are you talking about fled the state or fled the county that has jurisdiction?
Fled the state.
So if somebody fails to appear, and we don't know if they've fled the state or not, they just haven't appeared for whatever court appearance, then there wouldn't be this exemption for those folks. Is that correct? Is that a yes? Sorry, I see.
No, it
Okay.
is. You've clarified the jurist. I correct my answer, Madam Chair. It is a question of jurisdiction. So thank you for your pushing there. And so if they cannot be found in the jurisdiction, then the criminal conviction requirement would be waived.
So I guess I'm still not entirely clear, and I don't know if maybe House Research could clarify if state jurisdiction means within the state, or is it if they didn't appear?
Madam Chair, committee members, I don't think I can add much to that. It's not defined within the bill.
Chair Lesch.
Madam Chair, I would reassert what Mr. McGrath said. It is a jurisdictional issue. Okay, so yes, if they did not appear, my expectation is that is forfeit. Now, if that is rectified later, that's a separate issue. But maybe we could That would be my understanding from the plain language of the statute. It's not so much where they went, because we don't know where they went.
Right.
All we know is whether or not the court has jurisdiction over them, and that's evidenced by whether there's a warrant or not.
Okay, thank you for that. Appreciate it. And then I had another question about, let's see. Section 12, well, subdivision 21, but page 12, and you talked about, it's the innocent owner, and you talked about the burden being on the government instead of the owner to say that they're an innocent owner? Did I hear you correctly on that?
Madam Chair, the owner has the initial burden of proving that she is the owner. And then after she has established that, the burden switches to the government, and this is what is different from today's law. The burden switches to the government that it must prove that she had knowledge or consented to the use of the vehicle in the crime by the suspect.
Okay, so the government has to prove, let me just want to clarify that, the government has to prove that the person claiming they're an innocent owner had knowledge of the whatever it is being used for the crime.
Or consented.
Or consent, okay. And then on page 15, just talking about how folks are paid back with this, and I just, maybe for clarity, on line 15.16, it says, pay the victim of the crime for which the defendant is convicted. Is that after restitution has already been ordered? I'm assuming there's maybe something that needs to refer to restitution here. Or Chair Lesch, would you have a comment on that, or?
I would defer to Mr. McGrath on
Okay.
that, Madam Chair.
Yeah, go ahead, Mr. McGrath.
But I would say certainly the intent is that restitution is covered. So in light of the fact that you need to have get a conviction and there is a sentencing pending, the jurisdiction of the court would have the authority to order that restitution. So.
And Madam Chair, Chair Lesch, some of that restitution implicitly could come from forfeited proceeds.
Okay, yep, and that's why I just wanted to make sure that we were talking about the same thing with respect to victims who've been ordered restitution by the court. I think those were the only questions I had. Do members have other questions for, oh, okay, Representative Carlson.
Thank you, Madam Chair. So, not being an attorney and having read through this, I thought it might be helpful just to kind of run through a couple examples of how this might play out. And okay, so if the police officer issues a search warrant and enters the home, finds drugs, money, firearm, everybody there denies ownership of the drugs, money, and the firearm. It is not abandoned property, but under this bill, what authority, if any, would law enforcement have in taking those, which may be construed as the instrumentalities, I think is the term used, that may have been related to a. So I guess I'll stop there, and if you could just answer the question.
Mr. McGrath.
Madam Chair, Representative Carlson, thank you. The police could seize that cash because it was there is an association, a link that they see. They have probable cause to believe that that cash is associated with illegal contraband, and the crime of that has a forfeiture punishment. The prosecutor doesn't have to, the prosecutor then would go into court and he would argue that this is abandoned property, that there is no owner who has come forward. All have disclaimed ownership of this property. So therefore, his burden under this bill to get a conviction as a prerequisite is relieved.
Representative Carlson.
Thank you, Madam Chair and Mr. McGrath. My notes say otherwise, that those, that the drugs, money, and firearms could not be. So I have some contradiction to what you had just said.
Madam Chair?
But perhaps that person can step forward and speak to that more clearly later. Yes, I'm sorry, didn't mean to interrupt.
Well, Madam Chair, I just wanted to say that, it may be worthwhile. I'm sure people are going to come up and testify in opposition, and it may be worthwhile for some of these questions to, let the talking heads, battle it out between each other rather than hearsay, because I'm sure whoever raised that issue are probably going to raise it at the table here as well.
So I'm open to that. Let's just, we had a couple questions from Representative Johnson and Chair Scott. And if you want to ask your questions now of the proponents, or would you rather wait? I can ask mine now. Okay. And before I do that, Representative Carlson, are you fine waiting, or do you have some more now?
Yeah, that sounds like a plan.
Okay, sounds good. So go ahead, Chair Scott.
Thank you, Madam Chair. And my questions are on page 15 as well, and it has to do with the court, starting with 1515. The court may then order that a portion of the currency seized or proceeds and going on from there. There's no set percentages here or anything. Just normally, how does this, well, maybe it doesn't even, I suppose it doesn't even happen now, but will it be up to the judge's discretion how to disperse those proceeds? Clear down to the state's general fund, I guess, if there's anything left. Because it seems to me that the majority of this, if there's a victim, should go to the victim. And how do you put a dollar value, if there's a victim, how do you put a dollar value on what, the wrong that they've endured, I guess? If you could speak to some of that language, please.
I can. Madam Chair Scott, so you are right to start at line 15.15. And as part of the restitution process on the next line, the victim would come forward and make a claim as to what it is that she hopes to be reimbursed for, and that could come out of various sources, including these forfeited proceeds. Similarly, a petition can be, on line 15.17, a petition can be made by law enforcement as to what their expenses are in terms of the time that the car sat in the impound lot, their costs associated with seizures, and any cost of maintaining and storing property. So those are pretty case-by-case specific. Who the victim is, what has happened to her, what is she owed, how long has the car been in the impound lot, what are the other costs. On line 15.19, the judge then may have some remaining funds, but once again, this is 1,549 is the number, and to keep in mind. But he or she may have some remaining funds, and she's charged under line 5.19 to credit equally. You can see at the end of that sentence the word equally, so she is to divide them up among those 4 different groups. And some of that money will go back to law enforcement under the Offices of Justice Programs. The Justice and Community Grant Program, for example, is designed to support efforts to prevent and control crime.
Okay. And then Representative Johnson, did you have a question specific to now, or?
I have a number of questions, some now, some later. I can wait. It's at your choice, but just one thing I would like to hear from especially Mr. McGrath. That would be, you talked about the drug task force issue, and we dealt with that issue very severely. What those officers did with the lack of administrative oversight was ridiculous, and as far as I'm concerned, the punishment they got was not enough. But that was 2010 when we found out 9 years ago. Is there anything that has happened since that time, other than these last two court rulings that we have, that the Supreme Court, and I think there was another court ruling that we have to deal with. That's one thing we do need to deal with this issue, but how we deal with it, I'm not sure. But is there anything since 2010?
I think I'll
Mr.
refer to Chairman Lesch to reiterate some of the problems that he's had with his claim, and Representative Kohler, Attorney Kohler also mentioned that in terms of the individual cases, that the system is designed in a way that does not give process to the vast majority of these cases, because it's designed for originally to go after large international drug cartels, and now it's focused on $1,459 seizures.
Well,
Chair Lesch.
Madam Chair and Chair Johnson, the high-profile nature of the gang strike force and drug task forces was that officers were personally enriching themselves. You know, I remember the gang strike force walking into a property room and taking a big screen TV and taking it home to put it in one officer's garage kind of thing. These are the kinds of things that everyone just throws their hands up and says, are you kidding me? That's what, was very high profile. The system that enabled, allowed, and dare I say, I shouldn't say encouraged, but that enabled that is the same system that we have in place today. That is we're going to take your stuff, prove we can't take it, and put forth enough resources to see if you care enough about this to decide if you're going to fight it, and in most cases, we know you're just going to slink away. In fact, I think it's 96% of the cases. We know that you're just going to walk away. So yes, it has been ongoing. And the example I cited of my client, who the injustice against her, who was never even a suspect in a crime, I think was a travesty. And the system didn't care. These are people that I know. I know these people personally, who were administering the system. And they didn't care because the system told them that they didn't have to care. And my client's situation is not the only one. I know of many others secondhand. So yes, it's still ongoing.
Yep, Representative Johnson.
Well, it's, in the situations I've dealt with it, I've never seen that. If a person needed their vehicle, they could bring their title in, leave the titles while the case was being gone through, they get their vehicle to use it. Law enforcement also, at least in my county, if the person that was picked up dealing with the forfeiture, law enforcement had to prove in court, or even before a county attorney would take the case, that that person was the principal driver and owner of the driver of the vehicle, not just because it wasn't the owner, because we've had a lot of situations where a perpetrator or a person that under this forfeiture, because of the type of things they were doing, they were having the vehicle, they paid for it, they were paying the insurance, but they have it registered in either their parents' or grandparents' name to bypass the forfeiture situation. So law enforcement always tried to prove that the person who was picked up in it was the principal driver, equaling the principal owner.
Mr. McGrath, any response?
No response.
Okay. All right, so why don't we go ahead and have the opponents come on down. I think, Bob Small, you're up first. And then Superintendent Evans, I have you on the list too, so if you want to head down. Hi, Mr. Small, welcome back to the committee. Please
Thank you.
introduce yourself and you can begin.
Certainly. Madam Chair, members of the committee, my name is Robert Small, and I am the Executive Director of the Minnesota County Attorneys Association. But I'm here tonight speaking not just for the Minnesota County Attorneys Association, but rather on behalf of the Minnesota Law Enforcement Coalition, which consists of the Minnesota County Attorneys, the Police Chiefs Association, the Sheriff's Association, and the Minnesota Police and Peace Officers Association. So that coalition represents all 87 county attorneys and their employees, all 87 sheriffs, more than 300 police chiefs, and 8,500 rank and file peace officers in Minnesota. And Madam Chair, I have a chart that I think might assist in my testimony as I go through. May I have?
Yeah, if the page could help distribute that, that would be great. Thank you. Go ahead.
Thank you. In recent years, both state and national drug policies have focused less on criminalization and more on health-based approaches. Indeed, our law enforcement coalition supported and was instrumental in the enactment of the Drug Sentencing Reform Act 2 sessions ago, which recognized the differences between those who are dealing with drug addiction and those who are dealing drugs. And while drug policies may have shifted, those in law enforcement know that sophisticated drug trafficking organizations are still flooding our local communities with illegal narcotics and making huge profits. There is no community, whether large or small, rural or urban, across Minnesota that is immune from this. And that's the reason that I wanted to pass out that chart. That is just in 2018, and it's from media reports, which summarizes just what happened in 2018 with respect to drugs, money, firearms, and ammunition in 2018. And so, for example, just to name a few, in Kandiyohi County, in addition to the drugs that were seized, there were numerous firearms, including a submachine gun, silencers, night vision goggles, a rocket-propelled grenade launcher, and more than 10,000 rounds of ammunition. In Blue Earth County, in addition to a large amount of methamphetamine that was seized, there is $12,000 in cash. In Olmsted County, in addition to the drugs that were seized, there is $23,000 in cash. In Hennepin County, along with the large amounts of drugs, there is $289,235 in cash seized. In Sherburne County, in addition to the drugs that were seized, there are 43 firearms and $14,000 in cash. So the list goes on, and they're included on that chart, and you can look at it at your leisure. And my point is that this is happening throughout our state. In addition to the information on the chart, you should also know that for the 11th straight year, the state's drug task forces in 2018 seized a record amount of methamphetamine. If you read this morning's Star Tribune, there was an article about methamphetamine seizures surging to 5 times the amount which was seized in 2014. After declining seizures, cocaine is back on the scene, and the state's drug task forces have seen an increase in the last 3 years in the amount of cocaine seizures. The task force is also seizing pills, liquid and powders containing fentanyl and other synthetic opioids, a highly dangerous substance that can be deadly in small amounts. Late last week, Minnesota law enforcement warned all Minnesotans that a deadly drug known as Mexican oxy could be circulating within the state, and investigators believe that those pills from Mexico were linked to a 38-year-old woman's fatal overdose in Blue Earth County. These multi-jurisdictional task forces, whose purpose is to investigate narcotics, gangs, and violent crime, have increased their efforts to prevent these tragedies, stop the drug cartels, eat into their profits, and identify major drug traffickers, focusing in recent years on high-level dealers and suppliers. It is a difficult job under the current statutes, and this bill would make it even more difficult. I have talked to my counterparts in New Mexico, where this bill, I believe, is modeled after, and my counterparts tell me that this is so cumbersome that forfeiture ceased to exist in New Mexico. Our teams are seeing organized drug dealers circulating in a circular fashion where narcotics are coming into Minnesota while the cash goes out. The cash profits are used to produce narcotics with a street value several times higher. Those narcotics then come in, the cash goes out, and the cycle continues. Civil asset forfeiture is a powerful tool used by police and prosecutors in Minnesota to break this cycle and deprive the criminals of their ill-gotten gains through the seizure of drug money. The forfeiture of property used by persons to commit crimes and the forfeiture of money and other profits derived from criminal activity has long been recognized by both the legislature and criminal justice professionals as a valuable means to enforce the law, to deter crime, and to reduce economic incentives for persons to engage in criminal activity. Unfortunately, this bill will dismantle civil asset forfeiture and, in essence, say to those sophisticated drug traffickers, come in here and do business in Minnesota. We know this proposal would dramatically and adversely impact public safety by making our state a safe haven for those criminals participating in the illegal distribution of drugs. It is important to understand that property seized in Minnesota under current forfeiture law must be connected to ongoing criminal behavior, and there must be a conviction of the criminal offense related to the forfeiture before that asset is subject to judicial forfeiture. Current law allows for a person to engage in a simple process and be heard either in conciliation court or in district court about why the property should not be forfeited. Current law also allows a person to talk to the prosecutor without the need to start litigation, and in the name of expanding due process rights and closing loopholes, this bill dramatically shifts the burdens and criminal justice resources away from protecting the community and afford expansive procedures to those involved in criminal behavior. In the end, this bill will result in the return of illegal proceeds or the instruments of crime to convicted criminals. The vast majority of forfeiture actions in our state involve the sale, distribution, and use of controlled substances. In a time when our state and our country is dealing with an opioid and heroin epidemic, which is claiming too many lives every year, we are struggling to keep up with the huge increases in methamphetamine use and the sale and distribution of other controlled substances, as well as synthetic drugs. Our coalition does not support this bill, which would, in our experience, make it easier for drug dealers to profit from their criminal activity. Now is not the time to make it easier for criminals to sell illicit drugs, and it is for those reasons that we oppose this bill. I would just like to respond to one question that was asked, and I don't know if I'm a talking head or what, but
We all are.
But the suggestion, and it's very uncommon, and officers in the back of the room were surprised to hear Mr. McGrath's response. Cops executing a search warrant go in, see drugs, money, guns. The drugs are contraband and can be seized. Under this bill, the money, and everybody says, not my money, which is typically what happens. Not my guns, not my money. It's not abandoned property. And under this bill, the police officers could not seize neither the money nor the firearms. I would also just mention, we were talking about distribution of proceeds. There's a provision in the bill that says if the public defenders represent the defendant in the criminal case, the public defender can represent the defendant in the forfeiture case. Then there's another provision, and if you look at line 15.21 to 15.26, some of the distribution of the proceeds goes to the public defender. So talk about a conflict of interest. The public defender would have an incentive to lose the case so that the money would then be forfeited and goes to the public defender. So,
Did I say well out loud? Well, I'm sure.
But hang on one second here. Are you finished, Mr. Small?
I am. Thank
Okay,
you very
thanks. Go ahead, Chair Lesch.
Madam Chair, members, to the perverse incentive highlighted by Mr. Small. Current statute, I have current statute up here in front of me. Property representing proceeds of a designated offense is sold. The proceeds must be applied first to satisfy liens, forfeiture sale expenses, so you can get the most expensive auctioneer or whatever you want, or legal fence. And after all this, 70% goes to the law enforcement agency, 20% goes to the prosecuting authority, 10% to the state general fund. Special formula applies to forfeited vehicles. 40% goes to the law enforcement agency, 20% to the prosecuting authority, 40% to the city treasury for distribution to neighborhood crime prevention programs. And then a special formula applies for human trafficking cases, 40% to the law enforcement agency, 20% to the prosecuting authority, and 40% to distribution for trafficking crime victim organization service organizations. And then the same allocation is made for prostitution cases. So I think Mr. Small is right. That perverse incentive exists, and he recognizes it to the extent that part of this money, a small percentage, goes to fund public defenders. But we have a glaring, gigantic elephant in the room with existing statutory allocation for existing seizures. But in this case, we're putting it under the rubric of the criminal law. So what is stated is that they can take contraband. And by the way, you can take the money and the guns too. You just have to get your conviction first, and you have to show that nexus. So I think it's reasonable. That's my answer, Madam Chair.
Might I just,
I think we're going to keep on going with the testimony right now, and then we'll have you stick around for questions, please. Superintendent Evans, if you want to come forward and introduce yourself again, and if you could please try to keep it to maybe points that haven't been addressed already. Great. Welcome.
Thank you, Madam Chair and members. My name is Drew Evans. I'm the superintendent at the Bureau of Criminal Apprehension, and as you request, I will try to keep it to points that have not been covered yet. Some of our concerns when we look at this is we've talked a lot about drug dealing in the state of Minnesota, and we share some of the same concerns when it comes to that in terms of ensuring that this is used as a useful tool to disincentivize committing crimes across Minnesota where you'd be profiting from drug dealing in particular. And when it comes to the seizure of these gains, that we do not create incentives to be laundering the money. In particular, there's some provisions in the law that would require that we prove directly that the ill-begotten proceeds are directly related to the underlying criminal offense, meaning that in a sophisticated money laundering scheme, for example, that could become difficult, showing that the actual charged offense is the underlying offense is directly connected to the money that was seized and related to that particular crime as we're looking at that. What we don't want to see is we see this also in crimes of human trafficking, financial crimes, and drug dealing in particular that we're looking at. This in terms of looking at those restrictions, as was noted here, and the other concern that we particularly have is it's not the matter of actually seizing and forfeiting at the end, as Chair Lesch noted. It's actually in the terms of actually seizing those items under this law for actual safekeeping in the process, in terms of until we get to the point of conviction. Under this law, I think it would be challenging in many instances is the pragmatic consideration of we are conducting a search warrant, we seize drugs, we seize the guns that have been noted, and we have the $30,000 in cash that's in that location. under the law as written, I don't see how we could seize that unless it's incident to a lawful arrest that we're doing here, which is not common with many of our cases. We're often conducting search warrants that's being seized. There may be a process that's in place that we look at how we can make sure to do that, but if that money is left with that potential person that often is charged with a crime later on, where that money goes in that process could be challenging in terms of tracking that money and going out to get it later on in that particular case. The last item that I would just note as a potential unintended consequence, I think that the testimony that was provided to you about federal asset forfeiture, federal asset sharing, is not entirely how it is used in Minnesota with all of our cases. Under this law, we oftentimes at the Bureau of Criminal Apprehension throughout all of our programs are working with federal agencies on human trafficking, on drug trafficking, on financial crimes. Often the actual forfeiture, if we decide to take a case with the federal agency that we're working on directly with them in partnership, is going into federal forfeiture at that time. And this bill then would prohibit any forfeiture to the state of Minnesota in that case, even though we're working with them directly. I think the concern has been that you do see that the scenario that was provided is that the agencies were simply bringing for adoption to the federal government that they had no connection other than to seize that money. That, I understand the concerns about that. I don't know that that's what's happening in all of our cases across Minnesota. And I would just note that, you know, the cyclical nature of the drug dealing, we see very sophisticated cartels operating in Minnesota. I understand that $1,400 is not a lot of money. I will tell you for this committee that when it comes to methamphetamine in the state, a pound of methamphetamine is currently selling on the street for about $3,500. On the street in Mexico, it's wholesaling for about $200. So those $1,400 continually going back, if it's not seized as this, does make a difference in the amount of drugs that can be coming back into Minnesota with these sophisticated operations that we're doing. And that is the goal from our law enforcement perspective at the BCA, is to ensure that people are not profiting from those criminal proceeds.
Thank you, Superintendent Evans. So let's go ahead and open it up for questions now. And if there are other folks in the audience who want to testify, let's just see a show of hands here first if you would like to testify. Is it just one other? There's two people I'm seeing. Why don't we go ahead and take your testimony first? And because I don't think you had signed up in advance. So if you could keep it under 2 minutes, that would be great. Thank you.
For the record, Colonel Rodman Smith, Director, Law Enforcement, Department of Natural Resources. Madam Chair.
Go ahead.
I did not plan on testifying tonight because I thought we had an amendment in the works. So I'll just read 3 sentences just to get some stuff on the record. So the Department of Natural Resources has concerns regarding the potential impacts of this bill and the agency's existing authority to seize and confiscate weapons and equipment used to take animals in violation of the state's game and fish laws under Minnesota statutes 97A221, 97A223, and 97A225. Ambiguity within the proposed bill language may lead to future legal challenges regarding the continuing existence of certain seizure and confiscation authority under game and fish law.
Thank you so much. I appreciate it. And one more person. Come on forward, please. Introduce yourself. And if you can keep it under 2 minutes, that would be great. Thank you. Welcome.
Madam Chair, members of the committee, my name is Curtis Hanna. I actually am one of the individuals that has had assets seized via the civil asset forfeiture process. The number was $1,800, which is very close to the $1,560 or whatever it is that's the national average. The seizure actually happened in Iowa about a decade ago. However, the laws in Iowa and in Minnesota were fairly similar at the time. But yeah, the situation occurred where I was arrested in a building. The keys were taken out of my pocket and taken out to the parking lot where my car was opened and the money was found there along with a little bit of cannabis. And because of the fact that my money is not a human being, it doesn't have constitutional rights. And so there was a dual track that happened where my money had one court case and me as a human being had another case. And my money didn't have any constitutional rights. And so therefore, that money, I didn't even attempt to try to save it. There's a saying that you shouldn't try to throw good money after bad, and it really would have cost me more money to be able to fight to get this $1,800 back than it would have been a benefit to get that back. And I just wanted to speak in favor of this bill because I have been following civil asset forfeiture throughout Minnesota, the legislature here for the last 6 to 10 years. And also, I do have some data related to a data request that I did with these drug task forces in Minnesota, specifically what they have seized and what they have spent that seized money on that I'd love to send to the committee. Thank you.
Right, thank you so much. Thanks for being here, and thanks for keeping it right at 2 minutes. We appreciate that. Good job. Okay, so I think, do you still have some questions, Representative Johnson? All right, go right ahead.
Madam Chair, Representative Lesch. Now, you know I have a lot of problems with this bill. I will be talking about an amendment later on this. But on line 7.17 to 7.21, talks about the jurisdiction issue. I'm just wondering how many years a person can have a warrant before that property would be considered abandoned.
Well,
Chair Lesch.
Madam Chair and Chair Johnson, I believe abandonment is fixed in state statute. So I don't know, but I don't know if Mr. Ben Johnson can.
All eyes are turning to you, Mr. Johnson.
Yeah. So I think it's already in there. But you know, a judge can take judicial notice of abandonment too, considering that there were repeated attempts to contact the party. So you know, I think the answer is a reasonable amount of time based upon what's already in state statute.
Do you have, should we keep going, Mr. Johnson, or, okay. All right, Mr. Johnson, Representative Johnson.
The reason I asked that, Madam Chair, Representative Lynch, I've actually had, it was a DWI case. We had the warrants out for the person for 7 years before we finally picked him up in southern Minnesota, brought him back up to go to court. 7 years. Now, with the way you explained it earlier, that then you could go back, once you just end up disposing of the property, but then you can come back after possible conviction or because of some other circumstances may have been found not guilty. And now, how do you get that property back to him?
Looks like Mr. McGrath.
Because
Sorry.
we need some timelines here, especially in this bill, so we know. Because there's warrants out there that people have had warrants for 20 years.
So in that, Madam Chair and Chair Johnson, in that section you point out to subdivision 12, simply the prosecuting authority just shows by clear and convincing evidence that any one of the list, so no longer in the United States, abandoned the property, fled state jurisdiction, or was granted immunity or reduced punishment. So just presentation of that, you don't have to wait 7 years.
Representative Johnson.
Madam Chair, Representative Lesch, but you also said that he'd have redeemable, or be able to redeem that later after he was picked up. That was your testimony. That's not in the bill, but that's what your testimony said.
No, I can't remember saying that or what I was referring to in that, but.
That's what I thought you had.
Okay.
Thought you had said. That's why I brought that up.
All right, fair enough.
And Mr. McGrath joined you at the table there. Did he have a response to that? Because I'm still a little bit confused about the fleeing provision also.
Madam Chair, the idea is not to create impractical obstacles for law enforcement, for prosecutors. A prosecutor should be able to go in front of a judge and say, we can't meet the conviction prerequisite here, and this is why, and this evidence is clear and convincing that the person has died. He has fled. He walked away from his property. He disclaimed property. We are attempting here to be as pragmatic as possible, and that petition in front of the court can happen within a very short period of time.
Madam Chair, I think we're we're stepping a little far afield of common sense here, okay? What was stated by law enforcement on the record here was that criminal defendants always disclaim the money that's found. You got a glass coffee table. There's 3 piles of blow. There's a scale. There's a pile of cash, and then, you know, a couple booze bottles or whatever. No one's going to say, well, you know, the blow's not mine, but that cash is definitely mine. No, the reason for that is the cash is evidence. The cash is evidence that gets seized. So you can seize that cash for evidence. And what's more, even if there's money in another part of the house, let's say they go into a shoebox in the far corner of the basement and find cash, well, this is definitely part of the proceeds as well. Well, no, that's mine. Then they simply have to show that no one is claiming that by clear and convincing evidence. So I think common sense is kind of taking a walk on this. And when you look at how the situation actually goes down, the academic or theoretical objections as to how this would work don't play out in a real scenario.
Okay, let's see. Mr. Johnson, did you have a response about abandonment yet? If you don't, it's fine.
Madam Chair, members, without additional time to research, I'm a little bit uncertain giving a solid answer here. There is a statute that generally relates to abandoned property, abandoned tangible personal property. It's section 345.75, and that requires that property be held for 6 months before it is treated as abandoned property. I will note that I think there are other provisions that relate to evidence and other property that might apply in these situations that would make the 6-month number not applicable in certain circumstances.
And Madam Chair, you know, I would just restate that I think that the answer is more than covered in subdivision 12.
Okay. Representative Johnson.
Madam Chair, Representative Lesch. I was sort of fascinated by the other number of 96% of the forfeitures are unchallenged. In the drug task force world, I know there's a lot of them that are never challenged. That's because we don't charge the individual. Why don't we charge them? Well, there's a couple of reasons. One, it might be that we want them to work with us and help us. We want to get that. We don't want the low level in the drug task force. They want to get that, the kingpin. They want to work that as far as they can. In fact, I worked one joint from a high school kid who happened to be 18 years of age. And they ended up working that not just as far in the state, I went as far as I could at the state level, but ended up federally. They went all the way down to the cartel because of that one marijuana joint. I didn't charge that kid. That particular one, I didn't take any money or forfeit any of that. But we had 3 or 4 along the way that we forfeited quite a bit of things. But we didn't charge them to get them to work. We were able to work that by using the forfeiture statutes and not giving them criminal convictions and wrecking their lives, but giving them help, but still having a penalty, and work that all the way to the cartel in Mexico and the marijuana grow. That's the advantage of the civil asset forfeiture. We can actually punish somebody for doing a wrong and not put it on their record.
Chair Lesch.
Madam Chair and Chair Johnson, I think you'll still be able to do that under line 7.18 and 7.19. If the person was granted immunity or reduced punishment in exchange for testifying or assisting a law enforcement investigation or prosecution, you're good to go. You can take it.
Representative Johnson, and we've got a couple other folks with questions.
Madam Chair, Representative Lesch, but the way I read this bill, you'd have to be initial charge. Because it has to go through the criminal court system. To do that, you're going to need the initial charge, and that's going to be on that person's record.
Okay. Well,
Chair Lesch.
Madam Chair, and Mr. McGrath can correct me if I'm wrong, but that laundry list between 7.16 and 7.22 is exclusive, not inclusive. So I think we are covered by that, but Mr. McGrath can.
Madam Chair, Representative Johnson, there are 2 dynamics in play here. One is the criminal charge. This bill does not limit the ability of prosecutors to make a criminal charge, or does it force them to make a criminal charge. This bill deals with the assets, the forfeiture, And it makes clear that a criminal conviction is unnecessary in cases of in cases, as you suggest, and on line 7.18, immunity or reduced punishment is granted.
And Madam Chair, that's what I meant by exclusive. You don't need it. You don't need the charge or the conviction if you've got any one of that laundry list. Person died, they don't live in the U.S., they fled jurisdiction, they abandoned the property, et cetera.
Is it, Representative Johnson, is it to this point? Because I'd like to get some other
Yeah,
questions.
Madam Chair, yes, it is at this point.
Okay.
Well, in subdivision 12, it says conviction required standard of proof. Yes, you don't have, there's some exemptions to the conviction, but in order to get to that point, you have to have a charge.
Well, I guess, Madam Chair Johnson, I would disagree. I disagree with that wholeheartedly. It says nowhere that it requires a person needed to be charged for that. A person need merely testify, yes, I gave him immunity, or, reduced punishment, which could be no punishment. So I don't think you need a charge, just no action.
Okay. Representative Lee, or Chair Liebling.
Thank you, Madam Chair, and Representative Lesch, I thank you for bringing this bill. First of all, I think we need to kind of go back a little bit and just remember what we're talking about here. We're talking about the ability of government to grab people's property and then put it on them to come and get it back. That's something that, when we think about this, we think about it in context of, oh, it's a criminal, it's a this, it's that. But a lot of times, it's just somebody who gets caught in a situation, and this is what we're talking about. Under what conditions should government be able to take your personal property, whether it's your cash, your car, your diamond ring, or whatever it is, okay? That's what we're talking about here. And Representative Johnson mentioned a situation where he wanted to, as an officer, wanted to punish somebody by taking the stuff. This, as I understand forfeiture, it's not supposed to be to punish people. Punishment is what the court does, not what the cops are supposed to do. That's not their role. The role of the court is to mete out punishment. Now, I grant you, often people are punished by the whole process, yes, but the goal of civil forfeiture is not to punish people. So I wanted to go back to this list of things that were seized that the gentleman had given us and his testimony. And I appreciated your testimony, sir, and I didn't catch his name. Law enforcement? Mr. Small. I appreciated your testimony, and it was very impressive. And first of all, I did want to say that the thing I really gained from your testimony is our law enforcement people really do a hell of a job for us. And I really do appreciate that, because when you think about the stuff they're going into and what they're taking, and the drugs now are very, very dangerous and all of this, there is no question that we owe them a lot. But that said, I don't know that any of, that this bill stops them from doing that job. And I think, in fact, the way we have our civil forfeiture now, where we let our law enforcement community keep a big chunk of the proceeds, and Chair Lesch read off some of this, how the statutes are, and our prosecutors keep a chunk of the proceeds, I think that undermines law enforcement, because I think at the very least, it opens to question whether people are doing this for the wrong motives. And I think that's unfair to put our law enforcement officers and our prosecutors in that situation. So I find that part of our current law very, very troubling, and have for many years. So that is one good reason in my mind to pass this bill. But this list that you gave us, as I'm looking at this and was listening to the testimony from Mr. Small, I'm just not seeing that this bill would prevent any of these seizures that are listed here. If somebody has 300 pounds of marijuana, that's obviously seizable. If you have, this Olmsted County, which is my county, 4 grams of cocaine, 6 grams of heroin, $23,000. I mean, if those are in proximity, I think that's going to probably be seizable. And, you know, and if it's in the vehicle, the vehicle's going to be seizable. And I don't see this law interfering with that. These are going to be probably situations where either you're going to get a criminal conviction, you're going to be able to make the forfeiture anyway under this bill, or you're going to be able to do it under the abandonment, as has been discussed here. I just really don't see that the bill is stopping this from occurring. Dangerous drugs that are contraband are always going to be seizable. And I just really feel that the bill strikes a much better balance for law enforcement. You know, you yourself said, Mr. Small mentioned this business about some of the money going to public defenders. Well, in the bill, I mean, I'd be fine with taking that out. But we're talking about in this bill, some of the proceeds being divided up, and the Board of Public Defense is a statewide agency. So an individual public defender who's representing somebody has almost no relationship to some money that's going to the statewide public defender. In fact, they probably get very little of it, unfortunately. So, you know, I'm not as worried about that, but what we've got now for law enforcement under current law is so much worse than that. So much worse. Our law enforcement should never be funded by money they grab from people in the course of their duties. It just puts them in a terrible situation. So I'll stop talking, Madam Chair, but it's very frustrating to me to hear some of the questioning. I think that we've been struggling with this for many years in this legislature. We certainly are better than when we started off. I really credit Mr. McGrath for a lot of that, even though there's a lot we don't agree on. We sure agree on this, because we should just not be doing this. It is wrong to make people come in and tell government why your property should not be taken from you. That is just not the right way to do it. The burden has to be on government if somebody's property is going to be taken. That just is the way it ought to be.
Thank you, Chair Levine. I just had a follow-up question sort of related to that, because we have heard some inconsistent testimony today about what do you do in this situation? What does law enforcement do in this situation when they find drugs, guns, and money at once? And can they seize all of that as evidence or not? So I don't know if either Superintendent Evans or Mr. Small want to address that one more time, because I did hear conflicting testimony about that, and that concerns me. Looks like, are you phoning a friend, Mr. Small?
Bob, hang on just for a second.
Okay.
Let me just get these things out of your way. All yours.
Say, while he's coming down, Madam Chair, members, Representative Leving, my point with respect to the public defenders was nothing other than we haven't heard from the public defenders. That was my point. I think my point has been misconstrued, that this bill impacts the public defender's office because currently they do not represent people in forfeitures. And that was my only point, is that maybe we ought to be hearing from the public defenders.
All right, so thank you for coming down to answer the question I have about what can actually be seized as evidence versus what would be forfeited. If you can introduce yourself, please, and answer that question.
My name is Joe Lico. I'm the Chief Deputy with Dakota County Sheriff's Office. So I assume we're under the scenario that it's in a common area with multiple people, and you have contraband to include possibly drugs, money in proximity. Today we can take that under the administrative forfeiture, even if everybody says that it's not theirs, there's no ownership. Under this new bill, I question whether or not you could take that. And oftentimes that's what happens. I worked in a drug task force for 7 years, oversaw the forfeitures, and the cases and number of times that we've come across either hides in cars where drugs are underneath the dashboard or in the trunk, and then multiple occupants. It's often very difficult to get a criminal charge, let alone conviction in those cases. And under those circumstances, we would not be able to successfully seize the monies in this new bill.
Thank you. And as you testified, I'm reminded of a situation a case that I read where a gun was hidden like up in the car in between everybody, and the driver was convicted, and the appellate courts reversed that conviction because they said the state couldn't prove who that gun actually belonged to. So that just came to mind as you were talking. I think Representative Carlson.
Thank you, Madam Chair. I'll be brief. So, I mean, I found the testimony today to be quite compelling from both sides here. And, you know, this bill is a big deal. You know, I can see where we want to remove the policing for profit incentive. That clearly is causing some problems with the current law. But I also want law enforcement to be able to remove a criminal's access to the instrumentalities to prevent the perpetuation of repeat crimes. I mean, this is what public safety is kind of all about. So striking this balance, I was hoping to get some clarity, but I too am left kind of conflicted in terms of how this bill would play out. And I'm hearing two different sides to the story here. So if it's not clear, let's all work together and try to make it clear. I'll also point out that the letter put together by the League of Minnesota Cities, I found by their general counsel, was also quite compelling in opposition to this. So they also, I think, spell out a convincing argument too in terms of some of the issues with the current language. So if it be an amendment, as Chair Johnson had mentioned, I would look forward to that. But again, I can see how this is wronging people in its current form, and we need to correct that. But at the same time, we need to allow law enforcement to have the tools they need to do their jobs as well to keep us all safe. So I was hoping for some clarity through today's discussion, but I'm still left conflicted in terms of with what we have before us.
Madam Chair.
Chair Lesch.
I have some concerns, and I'm sure that it wasn't intended to be this way, but the suggestion that you find a pile of money and you find a pile of drugs together and guns and a digital scale, the suggestion that now they couldn't seize that or part of it because of this bill, I don't think the bill's been read, maybe, or I can tell you, members, you can seize evidence to use to convict someone. If your intent is not just to fleece someone, but if your intent is actually to prosecute someone, so there's evidence that you collect with the intention of using it in a prosecution, that has a categorization under the Minnesota Rules of Criminal Procedure, and there are processes for that. The broadest categorization is material evidence, okay? And that is evidence is material in that it plays some role in the matter that gave rise to the litigation and can be introduced as evidence as such. Now, it might still not be relevant evidence. It could be excluded as relevant. But relevant evidence is evidence that would tend to suggest the existence of an asserted fact is more likely than not likely, which I would claim that a pile of money sitting next to drugs would suggest if your aim is to try to assert that there is a sale or possession of narcotics for the purpose of distribution, money next to it is relevant, not just material. But we're talking about simply material evidence. So I think that the suggestion that, oh, we couldn't get the bad guys, remember, there are at least 7 other states that have enacted it. 7 states? Well, just say yes or no. If it's not 7 states. Okay, New Mexico.
New Mexico, Nebraska, and North Carolina.
Okay, Nebraska, North Carolina. Okay, so I don't think that the bad guys are slipping through their fingers too much there. But, well, I'll just leave it at that. I'll leave the rest of my stuff for closing comments, Madam Chair.
Okay, so it looks like we have a couple of members who haven't had a chance to ask a question yet. So I'm going to go to them next, Representative Barr, and then Representative Cantrell.
Thank you, Madam Chair. Representative Lesch, I just wanted to say thank you. This restores property rights, actually it's my stuff. You haven't proven that until you prove I did something wrong, it's my stuff. Don't take it away from me. So I appreciate the restoration of property rights, and also the innocent until proven guilty parts. I just wanted to say thank you for bringing this forward.
And Representative Cantrell.
Thank you, Madam Chair. And Chair Lesch, just so I understand, essentially this bill just clarifies that if an asset is to be seized, that there has to really be, I think, a reasonable assessment that it might be in some way related to the crime for which an individual could possibly be charged with. And if that asset is completely unrelated to said crime, then it can't be seized. Is that a fair assessment of your bill?
Madam Chair, Representative Cantrell, yes, I think it's fair. And I would even go so far that it's broader. The state may request an ex parte preliminary order to attach, seize, or secure personal property for which forfeiture is sought. And application is subject to state court and rules. So it's even broader. They don't even need to prove. I mean, the forfeiture is predicated on that this is the instrumentality of a crime. Okay? That's not what it's been used for, but the philosophy is predicated on that. We're still providing for it to be that broad if they make that showing.
And let's see, we'll do Chair Scott, and then we'll finish with you, Representative Johnson.
Thank you, Madam Chair. And I hope that this will put some of our discussion and kind of gray area to rest. But if you look at the bottom of page 7, 7.27, and then through the middle of page, well, all of page 8, it talks about what you have to do in order to seize that property. If you see the proverbial big pile of cash next to the drugs. And as I read this, at the top of page 8, let's see, where did it go? 8.5, upon application of the prosecuting authority, the court may enter a restraining order or injunction or take an action, other action to preserve the availability of the property only, and then it goes through what you have to do there. And to me, this is setting out what you have to do in order to preserve that property that's going to be used to prosecute and hopefully convict. And then there's a time limit on how long you can keep it. So anyway, a notification to the owner or all persons that might have an interest in that property. So I feel like that is covered. So that was just my comment, Madam Chair.
Thank you. Representative Johnson, and then we know that you have an amendment also to offer.
Madam Chair, just to a little response to Representative Liebling's statements. We have this list of some very good seizures. And I would bet if you actually look into them and talk to the law enforcement officers or the task force members involved, there was a number of individuals that may have had property seized, but were never charged. There have no court record of even being involved to hurt their personal record. But because of the work they did and what they chose to do, we were able to get some very good seizures and a lot of drugs and a lot of firearms, illegal firearms, off the street, so which is a good thing. And that's how the current system works. Also, you talked about, Representative Levy talked about the funding going to too much to the law enforcement agency. Now, I'm going to use the DWI forfeiture. You forfeit the $2,000 car. If you pay an auctioneer at a local auction, you might get $800 for it. You take away the auctioneer's fees, the advertising fees, you have $300. There's no value in it. A lot of them have gone to online auctions. They're getting averaging about $1,000 to $1,200. Once the car sits so long through the forfeiture process, the value goes down dramatically. The vast number of cars are not high-value cars. They're lower-end cars, unlike Mr. McGrath is very familiar with the one particular case that happened in my district that actually went up to the state Supreme Court, and the forfeiture process was held constitutional. So, but with the funding, also with the funding, if you actually look in the current statutes, it limits and the statutes to prescribe how the funding can even be spent. law enforcement can't do all their work with the, and do their budgets, as they're saying, with the forfeitures. There isn't that much. My county total, before the splitting everything up, is maybe $20,000. And those funds have to be used for either drug, alcohol, education, or enforcement programs. It cannot be used to just put a guy on the road or fill the budget holes here and there. There's not enough money for that. And there's not, by statute, they can't do that. You see a lot of cash up on here, but these are probably the only ones that were that large. The vast majority of them are not that big. So I hope that answers, you understand a little bit more.
Chair Leland.
Thank you, Madam Chair. Well, I don't have the figures in front of me, but the Office of the State Auditor collects data and has a report on this every year, and it's in the millions. I mean, I think it's like $6-7 million a year, if maybe Representative Lesch knows the number, but it's a lot of money. So it adds up. I don't know whether they're doing a lot of small value cars or it's a mix of this, that, and the other thing, but it adds up to a lot of money.
I really don't want to back and forth.
I know, I
Last
understand
point,
that
please.
report.
Okay.
The report is, they also include the value of all the drugs that were seized. That's where the big portion of the dollar amount comes from.
All right. Would you like to go ahead and offer your amendment, Representative Johnson? I think it's the
Members, I have the DE1 amendment. As you can tell by talking, we all have concerns. It's a very contentious issue. What this does, we had the 2 court cases, at least 2, and there might even be some more court cases dealing with civil asset forfeiture, and including the federal Supreme Court, which just came down not very long ago. I think it's like 2-3 weeks ago. So what this amendment does, makes a working group. Basically, all the stakeholders, the public defenders, which were mentioned, I believe it's there's 5 members: the Commissioner of Public Safety, the Attorney General, County Attorney's Office, Association of Sheriffs, and the Chiefs of Police. And if there's another 1 or 2 that you think should also be in this group, to sit down, discuss it, go over the court hearings, have a good understanding, look what other states have done, and bring their recommendations to us next year. And no matter what, we will be dealing with this next year.
Chair Lesch.
Madam Chair, members, we've had our working group. We've had our working group for 16 years since I've been here. Members, in 2003, we had a $5.4 billion deficit between the existing fiscal year and the out years that we had to solve. And up until that time, the gang strike force had been funded by state and local funds. And we unfunded it and encouraged them to go on operating by seizures and forfeitures. Then in 2005, we recreated that gang strike force. We knew what they were doing. We knew what they were doing at the time, members. And we still did nothing because they were lean budget cutting years. We couldn't offer them any money. We thought, well, let's let them keep on operating like this in 2005. And we did it, and 4 years later, we had the Lugar Commission, where they were taking property for personal use. And then in 2010, Mr. McGrath came forward, and we were offering a series of reforms that we enacted and passed some of them over the subsequent 9 years. That was our working group. That is our discussion. I think during that time, members of the Law Enforcement Coalition had opportunities to come forward to help craft a real solution. And they've been part of it in some occasions and not part of it in others. But in reality, I think we're overdue. And so I'm opposing your amendment, Chair Johnson. I think you knew that I would, but I think we're way past the point where we can have a discussion about it. I have a 2.5-year-old at home, and we're in negotiation phase. Okay.
Good luck. You're not going to
And
win.
she blows it for time after time and throws a tantrum. And after, I'm like, okay, we counted to 3. Now it's consequence time. She knows what a consequence is, too, because she loudly announces, am I going to have a consequence? At that time, she wants to negotiate. And I say, no. I know you guys all think I'm a flower child liberal, so I do that. But I don't. No means no, yes means yes. And once you blew your shot, now it's consequence time. So I think that's what this bill is, and that's why I oppose the amendment.
All right, so Representative Johnson has moved the DE1 amendment. Any further discussion on that amendment? Chair Scott.
Thank you, Madam Chair. And Chair Lesch, just to get on the record, you're not opposed to the law enforcement community working with yourself and Mr. McGrath as time goes on forward through here, right? You would welcome their input?
Madam Chair and Chair Scott, absolutely. Yes, I welcome input and discussion and work going forward.
All right, any further discussion on the motion? Representative Johnson.
Members, I would actually ask you to support this amendment. Like I said, we have a Supreme Court ruling that we have to deal with. It's only about 3 weeks old. I don't know about you, but I haven't had a lot of time to even look at it as we discuss this. We've had committee meetings 4 days a week now. It's real difficult to study between all of our committees 40, 50, 60 bills, let alone a Supreme Court ruling, plus the other court rulings. Last year, Representative Knobloch, the Chair of Ways and Means, had this bill. And I had asked that until he works with all parties involved, that I would not hear the bill. He had one meeting that I'm aware of with the law enforcement side of it, and they were never asked to come back to work on it, even though they tried. So it's been both sides having issues, but like I say, if we bring this forward, they don't work together, do the things that need to be done, gives us time to actually dig in and look at what's going on in other states and what the ramifications of the Supreme Court ruling is and the other court rulings, where we can put together a proper bill to do this properly. And with that, I hope for your support.
All right, all those in favor of Representative Johnson's DE1 amendment, say aye.
Aye.
Opposed, say nay.
No.
The motion does not prevail. The amendment is not adopted. Members, I'm getting a note here that the author does want to consider an author's amendment, whether
Yeah.
it's the A1 or the A3, if you want to do. And I'm also understanding that Mr. Johnson could explain those amendments too.
Well, before we have them go through the explanation, maybe we decide which one we're going to offer. Which one are we going to offer, Ms. Ganani?
So I believe, I'll just give what I think is my understanding of it, that you had posted the A1, and then the A2 is the amendment to the amendment, and that the A3 actually incorporates both the A1 and the A2.
Madam Chair, that's
Mr.
correct. The A1 was posted. My understanding is there were some requests from the interested parties to make a few slight changes, including one technical error that was made on my behalf. And the A2 is either an amendment to the amendment, if the members want to take it up that way. The A3 is the corrected version and would effectively replace the A1.
Okay, I don't have the amendments in front of me, so.
Okay, could a page get the amendments for Chair Lesch? And it sounds to me like you'd want to move the A3.
It helps them dodge environment. That's all I know, Madam Chair. So what are the two, the A1 and the A2? What do they do? Oh, there we go.
Madam Chair. Madam Chair.
Yes, Mr.
So
Johnson.
A1,
Madam Chair, Mr. Scott, Mr. Lesch,
97.
Representative Lesch, it's getting late. The A3 amendment is what you
I
want
get
to
it.
offer.
I get it. Yep, okay, that's fair. Yeah, I offer the A3 amendment, Madam Chair.
Okay, is there any discussion about the A3, Representative Johnson?
Members, this amendment excludes the Department of Natural Resources Division of Enforcement from the changes in the forfeiture law. Now, the Department of Natural Resources, they already have a lot of advantages in the forfeiture issue. In fact, any law enforcement agency across the state that forfeits a boat, a snowmobile, an ATV, any proceeds from that, the proceeds go to DNR. They don't stay in the local community to help the local community with some of the drug and alcohol programs that most of the forfeiture money goes to. It goes to DNR. But they're excluded from this so they can keep forfeiting and keeping all the cash, funding their department. Which is exactly what Representative Lesch wants to end. Now, take fishing. You have a few too many fish in your boat or your back of your pickup, pulling your boat, your $60,000 pickup in your $30,000 boat, and you get pulled over, you have 3 too many fish. Oh, DNR forfeits your boat, your car, your trailer, $100,000. That is in violation for what the Supreme Court ruling that just came down. The punishment was more than the actual penalty. You could do this with hunting. We've had farmers doing stupidity things like poaching deer and hanging them up on their $500,000 combine as they're going down the field. DNR catches them, they forfeit that $500,000 combine. If we're going to do this for law enforcement, DNR needs to be included. They're the biggest abusers of it.
So
Go against this amendment.
Thank you, Representative Johnson. I mean, this is just to put the bill in the format the author requests. Is that
Yeah,
correct?
Madam Chair, we're only doing this so we meet deadlines. And I'm sure DNR is going to be in it in the Senate, and I'm willing to bet we're going to take that language at the end of the day. So it'll include, so we're offering it, so we're not going to environment.
Okay. So, and again, just a reminder, we're doing this just to put the bill in the format the author
Correct.
requests.
That's right.
Chair Scott?
So, thank you, Madam Chair. So I am not clear what you're doing with this amendment. You're putting this amendment on so it doesn't have to go to environment?
That's, Madam Chair and Chair Scott, yes. No, not with the amendment, it shouldn't.
Wow. Well, I don't know that I can support this amendment. But
Okay.
Okay. Any further discussion of the amendment? Seeing none, Chair Lesch moves that the A3 amendment be, I'm not saying this the right way, I'm sorry. Chair Lesch has moved the A3 amendment. All those in favor say aye.
Aye.
Opposed? No. Motion prevails. All right, so with that, we have House File 1971. Did you want any final comments, or is it okay if we wrap this up?
Madam Chair, I will say briefly, I got one sentence to tell you. Now, you can guess who it's from. Civil forfeitures have become widespread and highly profitable. This system, where police can seize property with limited judicial oversight and retain it for their own use, has led to egregious and well-chronicled abuses. Members, that was in an opinion. The majority opinion was from Justice Ruth Bader Ginsburg, but that statement was made by Justice Clarence Thomas. That's what I'll close with.
All right, Chair Lesch moves that House File 1971, as amended, be recommended to be re-referred to the Ways and Means Committee. All those in favor of the motion say aye.
Aye.
Opposed? No. The motion does prevail. House File 1971, as amended, is recommended to be re-referred to the Ways and Means Committee. Now, before we go, members, I understand that we have not approved the minutes yet from March 7th, 2019. So Chair Scott moves that we approve the minutes for March 7th, 2019. All those in favor say aye. Aye. Opposed? Motion prevails. The minutes for March 7th are approved. And thank you, everybody, for staying late tonight. We are adjourned until tomorrow.